This is 10th ADJ, no? So this will be third floor. It come towards the end of the corridor. हो गया किधर रखूं गिरेगा नहीं ना
Pertains to KLGP, my lords. It was listed today. Date was given today, my lords. Because of some miscommunication, it was not, the file was not found. There is some urgency in this matter. Kindly,
No, just show us.
please, madam.
Is the date for today?
Yes, my lords. It was, file was not found by the staff people. At 5:30, they got the file. The board was already closed. That was the reason they gave to me.
Just check up this order.
Where it is, lately something that. Not from here, right, not from,
It is listed today.
no, not it.
No, but the date is for
Yes.
today, no? Then it must be listed. Why does it say?
Because today's date, it's a
It's not. Then we must list it. Just confirm it is it.
Date not given, artificial date 14. They are not given the date and artificial. Amount is-
Please say.
The date is not on the files. Date given by court on the person, not on the.
Oh, not on the.
They have moved, no, date given for today and then.
No, 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 no.
Six, eight, 14.
To be listed. She made before.
Yes, sir.
Yes.
Here
It
only.
will be listed before us.
Yes, sir.
Because which are not other roster, I can't mention it here.
No, sir, this is here, this roster is here,
Roster is here. But they have said 14.
14. And memo, we have given the data 14 weeks, sir, but not listed, that's why they are asking for 230.
Yes, since we have given a memo, we must list it.
230, sir. But they are asking for 230.
In any case, when the matter will be listed, it will be listed in the list. List.
230, they will.
It's not listed, since the date is today's date, so they are asking for 230. So we-
Date 230, they are.
Since we have given the date of 14, it must be listed. Not necessary to, we can list it. Just list it. This is the memo date,
So, sir, memo.
then we must list it.
Some of that was today not required. Then it's 230.
We have given, we have
End of the
given,
list.
Will is separately list will come.
That's right, yes.
we have given a date in memo, it must be listed. Just say date as per memo.
Officer,
See, you have to inform the other side. Who is the other side? You have idea, just show us the details of the case to them. There was a memo file for which we have listed today. It was not shown in the list, but we will list it today because the date is today's.
number ತಗೊಳ್ಳಿ, sir, number ತಗೊಳ್ಳಿ. Sir, they want to comply the office of.
If they have to comply, they will comply. We say nothing on this. You have to comply, you have to comply. We say nothing. Whatever. Louder, louder. Use the mic.
My lord, one fresh matter, my lord. My lord,
Is the matter.
the petitioners are unauthorized cultivators, my lord, and
Writ petition or a
writ petition, my lord, writ petition, my lord.
What is the,
Classification KLGP, my lord. By challenging the order of the land tribunal, I'm sorry, land grabbing court, my lord. Fresh matter.
Not for land grabbing prohibition.
This is the act going to land revenue act. So
This comes on the stuff. But just give it in, when will you give it?
4 months.
Please.
And you should.
No, sir, they have to, we'll write and put in.
Take an acknowledgement from the other side.
My lord, this is a fresh matter, my lord. The matter is filed challenging the order of the state consumer, my lord. Where the state consumer does not have jurisdiction to try this matter. There was a JDA which was entered between the petitioner and the respondent, and the matter should have been tried before the commercial court. Instead, the respondent went before the state consumer and filed the matter, the order was passed against us. Hence, challenging the order, we have filed this petition. There's a 3 matters, all family members. Connected.
Three.
Similar matter.
What is the date? Now, is it still pending there before the state commission?
No, it is disposed, my lord.
Disposed of?
Yes, my lord. We got the order on 23/7.
Just give it according to commission.
Sir, 9.
My lord, our only apprehension is that there is a limitation period for that. There's a 45 days limitation.
You have filed it here.
Please,
That's right. Stop. It will stop running.
Alright.
Whatever is worth, it stop running. We will give you a date convenient to us. Rest be assured.
my
We'll take it up.
only submission is, there we have apprehension that they might file an execution petition challenging the state consumer.
What is the date of the order?
23/5, my lord. But we received the order on 23/7. From that
What is the
date,
date
45
of-
days.
What is the date of compliance? How much period of
45
compliance?
days
45 days.
Hmm.
That is 1.5 months.
from
after
23/7.
We'll have it. We'll have it on 23, the 9th of September. Next.
For adjournments,
Serial number 17, my lord.
page number 4, 17.
17. For appellant, my lord, and from the other side. Kindly a week time, my lord. Some inconvenience, my lord. Senior counsel has
See,
been.
there are certain notices which have to be issued.
In respect of connected matter,
That's right. Who appears for the other side?
other side, in my appeal, I have informed, my lord. In respect of connected matter.
Just wait then.
I
Let
will.
the matter be called.
Settled.
Serial number 6, my lords.
Sir, 6 orders.
Orders. Please.
Page number 5, 18.
6, you appear for whom?
Because I appeared for the official liquidator, my lords, the respondent. The respondent, official liquidator of the
Do
respondent.
you
my
want
lords.
to mention this matter?
My lords, I need to seek an adjournment, my lords.
Let's wait. Let the matter be called.
Serial number 18, my lords.
Sir, page
Serial
number.
number
18. I'm for the appellant, my lord.
8.
18, 1-8.
That's right.
I'm for the appellant, my lord. I have informed the other side also. I have engaged the services of senior counsel, my lord. He was not feeling well, so he
Who
could,
is, who is not feeling well?
senior counsel, my lord. So I request kindly have it next week, my lord. Kindly have it.
Council arguing counsel stated to be unwell, re-notify on.
12-9. Page number 6. Page number 7, 25 to 30. Page number 8, 31 to 36. Yes. Serial number 1 for non-compliance.
For the respondent statement.
How an habeas corpus
Lords, the petitioner has not seen the minor child since 75.
Seek your remedy.
Lord, petitioner had.
Tell us one thing. You have a remedy elsewhere also?
Lord, I just want to make one submission. I'd like to take your lordships to page number 15, which is an Exhibit C. Lord, this is a divorce decree already granted by a US court. I would just like, I'll not take more than 1 minute, my lord. It's a order granted by a Texas court. My lord, I just read the first 2 lines. Petitioner, that is respondent number 4. Respondent number 4 in this petition appeared in person through her attorney and announced and ready for trial. Second line, my lord. Respondent Jawahar Raj Muthappan Selva Raj, although duly and properly cited, did not appear and wholly made default. Lord, this order has been passed ex parte against the instant petitioner. My lord, however, a joint custody has already been ordered in favor of the petitioner herein.
That's right.
And my lord, may kindly have page number 17. I just like to read out a few more lines.
Yes.
It is ordered that Magdalene Divya Devaraj and Jawahar Raj Selva Raj are appointed joint managing conservators of the fallen child. Lord, herein the rights and duties of the respondent number 4, and at the bottom petitioners are given, my lord, by the honorable court in US.
We agree with you. There is a joint visit, joint rights, custody have been given to the parents.
My lord.
So then remedy is surely not a habeas corpus. In terms of this order, if they violate this order, you have a remedy elsewhere,
My lord,
not an habeas corpus.
Lord, if you may, Lord may kindly grant me 1 more minute, I'll just.
Yeah, take your time.
Lord, page number 18, my lord, it is ordered that at all times, Divya Devaraj and Jawahar Muthappan shall have the following duties. The duty to inform the other conservator of the child in a timely manner of significant information concerning the health, education, and welfare of the child. My lord, as per the information of the petitioner, she resides within the jurisdictional limits of respondent number 3, my lord. And the petitioner went to the respondent number 3 PS and asked, tried to register the complaint, but it did not take any cognizance.
What are you seeking? The compliance of the order passed by the US court?
No, my lord.
Are you not seeking?
Lord,
Based on that order?
no, my lord, I'm just seeking a writ of.
Where is the illegal custody? Tell us, where is the illegal custody?
Lords, we're not aware where the child resides.
You don't know, you may have a remedy, but that's not the reason. There is an order of the court. You are not challenging the jurisdiction. Rightly or wrong, there is an order. Joint custody has been given. If there is a violation, you will have your remedy. But where is the illegal custody? None whatsoever.
Lords, we don't know the exact address of the minor child.
We are with you on that. The interest of the minor child needs to be seen, but he is in the custody of one of the biological parent.
Lord,
On the strength of the court order. You are only seeking visitation to the child. You have a remedy in terms of that order passed, but how an habeas corpus?
Lord, I am the father of the child.
Right?
And as of today, we don't know whether the child is kept in a proper manner, whether he is imparted education. I don't know whether even whether it is residing with respondent number 4, lords.
The custody with the mother is in terms of that order of the court?
Lords,
Yes or no? Yes.
as per the last.
Where is the illegal custody? These are, let's not, let's draw a distinction between a habeas corpus per se and a case of a visitation right. Let's make a difference. This is a nature of a rate for a different reason.
Lords, my humble submission, Lord. Your lordship may order as you deem fit. Lord, the petitioner visited the respondent number 3 PS. He has strong apprehension that the
Who is
minor
respondent
child.
number 3?
Respondent number 3 is Hebagodi PS.
Lord. Kindly see the amendments made in the petition. No part of cause of action arose within the state of state.
Pardon?
No cause of action, no part of cause of action arose within the state of Karnataka. Kindly see the entire amendments, Lord. The address of the advocate is within the limits of the police station and is gone to the police station. Kindly see the amendments made now. They return from US. The cause of action occurs in Coimbatore.
Where is the respondent number 4 staying?
My lords, we don't know the exact address of respondent number 4. My lords, however, the petitioner went to the respondent number 3 PS on 12th. That is when the cause of action arose, my lord.
How
No
is-
allegation.
How is going to respondent number 3 will give you a cause of action? We don't understand. This
Not-
is the way the cause of actions are being, being taken for granted. Yes, I went to the police station, it's a cause of action, I'll file a petition.
My lords,
The cause of action is your grievance is for whom? Your grievance is for.
Lords,
Lord,
as per the last information, my lords, the minor child is residing with the mother, respondent number 4, within the territorial jurisdiction of respondent number 3.
It is not said so in the petition. Let alone R3, not even
Where
within the
is,
state.
where is the prayer that she is staying within the jurisdiction of this court? Where is the averment? And how will we serve respondent number 4? How will we serve respondent number 4? And how will they also go and search for her? See, they should have some indication where is she staying. Yes,
Lord-
all these are unanswered questions. You getting the point? Let's see, how will the court issue notice to respondent number 4? Who has to answer your prayers in the respondent number 4? They will do it. How will they go? Where will they go? You better think over it, but you withdraw this petition.
Lords may kindly grant a short date.
Pardon?
Lords may kindly grant a short date.
We don't understand what remains in this. See, these need to be thought over, before you actually file a petition.
Lords, we could not trace the exact address of the respondent number 4. Only there was an apprehension, I admit, my lord, before your lordship.
Will that apprehension suffice for this court to issue notice for them to make any investigation? There should be some foundation for the petition. Getting the point? Should be some foundation, and that foundation is lacking here. Just think over it, pass over.
So. Here number 2.
For the petitioner in this matter. As per the office
for the
petition,
respondent.
I have already served the caveator, advocate appearing for the caveator on 9th of July, 2024.
I have received a copy.
This shows. You appear for whom?
I appear for the respondent in this, sole respondent.
Proof of service was also filed on the 12th of July, 12th of August. I'm
You
sorry.
appear for all the respondents.
There is only one.
One
res-
respondent.
There is only one respondent who is a builder, Your Honor.
And what is now, what are you claiming in this petition?
I'm claiming that the order passed by the State Commission, State Consumer Commission, is completely patently illegal on 3 accounts, as held by the Honorable Supreme Court. Petitioner is a home buyer who signed a sale agreement in
You
2000.
file, you just say that, issue notice.
I've sought for a stay, Your Honor, because my execution that was pending before the District Commission was dismissed by virtue of the order. The order is patently illegal.
Eh,
I was successful before the District Commission.
See,
Money
we have
was,
to we have to decide this issue. Without that, how can, the state commission has taken some stand, some.
which is contrary to the express language of the statute.
Very well. Now, can we at this stage state and so that you can proceed with your execution and get the order implemented and make this appeal infructuous? Tell us. That the district court gave the judgment in your favor.
Please,
They went in appeal. To some extent, they have set aside the order of. the
without
district.
making a deposit, which is not permitted, is my submission.
My lord,
What do you
in
say
a-
on
in
that?
any case,
The Honorable Supreme Court has held,
1 minute.
please,
What do you say?
in any case, under section 51 of the Consumer Protection Act, an appeal lies to the National Commission. Admittedly, this is an order on the merits of the matter.
Yes, how would you answer that?
please. My
And
respectful
we'll be
submission on
permitted
that
to File
count
this memo also.
is that
but-
this is a case where the appeal would not lie because the appeal under section 51 is purely on a question of law, which would be a statutory question of law, not a constitutional question of law. Because if there is a constitutional violation and the order is patently arbitrary, then my remedy would be before this honorable court.
Why this plea is not available for you to take it before the National Commission?
Your Honor,
You said, the ground is the State Commission had no jurisdiction to, in the manner which the State Commission has said so. If you see the impugned order, the State Commission has set aside the order of the District Commission in para 6 to the
Please.
extent it has set aside this, quashed the sale deed,
the finding,
directed the payment.
please, the finding is contrary to the records of the case. Because what they say is that the district,
We are only on a question of law for it to be maintainable before the National Commission.
please, my submission on that count, Your Honor, is that the Honorable Supreme Court in the case of Raja Matthew, which is placed before the Honorable Court, says that where the tribunal, the bench of a tribunal is not in, it was a single judge's decision and a decision rendered by 5 judges, which is not where all the judges gave separate concurring opinions. The Honorable Supreme Court says that where the tribunal is not located in that state, I would have a remedy under Article 227 to approach this Honorable Court. That's my first submission. The judgment is placed before this Honorable Court.
We are only on a remedy which is available under the Consumer Protection Act.
Your Honor, my respectful submission is that if the State Commission had taken a view that is permissible within the folds of the statute, then I would have no case before Your Honors. In this case, the State Commission entertains an appeal. There is no stay granted. There is no deposit, which is mandated by the statute, and the Honorable Supreme Court interpreting section 51, which is pari materia with section 41. 51 deals with appeal before the National Commission. 41 deals with appeals before the State Commission. The second proviso says that without making a deposit, no appeal shall be entertained. Therefore, without having required them to make a deposit, 12 hearings are conducted. The entire trial court record, that is a district forum record, is ignored in a 3-page order. And the express finding is contrary to the records of the case. In fact, the finding that the district forum has ordered for cancellation of sale deed is not even a finding.
Admittedly, this is an order that is passed on merits. It is not their contention that the State Commission did not have
He is
jurisdiction.
right in saying so. Where is
They
your
participate in the proceedings.
Where is your objection? On pre-deposit?
They have,
Even regarding,
Where is the objection on pre-deposit? We are just asking simple, which has been recorded by the State Commission.
please, Your Honor.
It proceeds to decide on merits.
My submission on that is that there was no, it was the duty of the Honorable Learned State Commission to have required a deposit. It was not as though they filed an application seeking waiver. They never sought waiver.
like,
So the question was only decided.
Not sought waiver, it was for the State Commission to look into it, but I will not argue the issue of maintainability without a pre-deposit. That's the submission you are making.
Kindly have the objections, Your Honor, that I have filed before the State Commission.
Your objection.
even
please.
regarding the pre-deposit, my lord.
My submission, Your Honor, is on 2 counts. One is on law, that even if I did not take that objection, and I will show that,
We'll show you. Come to para 6 of the impugned order. That
Please.
itself is a question of law.
please, Your Honor.
The
Has-
District Commission has no power to cancel the sale deed and direct payment of the entire. This itself is a question of law.
If the District Commission had cancelled the sale deed, but the District Commission has not cancelled the sale deed.
Very well.
So this is expressly contrary to the order that is under challenge here. And kindly see the manner in which the appeal was instituted. A person who is not the partner of the firm files an authorization. Kindly, if the authorization is seen, the appeal is not even properly instituted.
See,
All
we-
these are
1 minute,
technical.
please. We don't understand why all these pleas cannot be taken before National Commission.
Ultimately,
There is a process which has been laid down. That process necessarily to be, followed. But to come as a writ jurisdiction, sometimes we have prima facie, we have some view on that.
with utmost respect, Your Honor, I rely on the judgment of the Honorable Supreme Court, which is filed before Your Honors. There are 3 grounds based on which a writ under Article 227 would be maintainable. And if I am not covered by that, then respectfully, I submit I have no case. I am covered by all three grounds.
Which are the grounds?
Please, Your Honor, I am referring to the judgment, the Honorable Supreme Court in Puri Investments versus Young Friends. So the memo is served on you, madam, it's on record. If Your Honors have the list of authorities at volume 1, the index at page 4,
Which paragraph you are referring to this?
I'm referring to para 14, which I have extracted on page 4 of the index. Specifically, page 5, the three grounds that erroneous on account of non-consideration of material evidence, nothing that was recorded, pleaded, or led as evidence before the district forum is even referred to in passing, being conclusions which are contrary to evidence and based on inferences that are impermissible in law. In fact, the Honorable Supreme Court has made the law very clear. The Consumer Forum has the power to direct refund, entire refund along with interest. None of those judgments are considered.
Which paragraph of this? This doesn't arise from consumer protection.
It was a proceeding under the Delhi.
Clearly a landlord eviction matter, landlord and tenant.
Please,
Yes. How is Puri construction, Puri investments will help you?
I'm purely on the principle of law laid down with respect to the fact.
We are with you on that.
Please, Your Honor.
If the district forum or the state commission had no jurisdiction in law, we are with you on that. The remedy is 226, without jurisdiction. But not in a case where you went to district forum yourself. Then they went in state commission. What is the remedy thereof? And it is not your case that it is not a case which is not covered under the consumer protection. You went yourself.
Please.
So you must seek your remedy there. Yes, we will not foreclose the remedy under 226 if in a given facts, there was no jurisdiction for the consumer, either the district forum or the state commission to entertain a petition. We are with you. We will interfere, but not in these facts.
In one last submission, Your Honor. In these facts, on jurisdiction, if the authority that is statutory in nature exercises a jurisdiction in a manner that is not given to it under law, then my respectful submission is.
You are not foreclosed to seek this, urge this ground before the National Commission. You are not foreclosed.
That is.
That's the jurisdiction of the National Commission.
Very well.
Okay, see, otherwise we will be confusing the jurisdiction everywhere. Everywhere people will go there, people will come here, total confusion. So we must, in a given facts, where the jurisdictional aspect is, inherent lack of jurisdiction.
I bow down.
For the district or the state, we are with you. But
This
it's
is-
not such a case here.
Fairly, that is not the case.
So go there. Okay?
My request is in that case, I may be granted some additional time because
But your against state commission, did you file this petition on time? Within
did.
the limitation?
We did.
contemplated? Then we will give you.
The order was passed on 3rd June. Statutory period is
If
already.
he has filed a writ petition within
That-
time,
that-
that we will allow.
It's clear, yes.
The, after some submissions, learner counsel for the petitioner seeks to withdraw the petition to enable the petitioner approach the National Consumer District Redressal Forum in accordance with law. Suffice to state that the present, suffice to state that it is the submission of the learner counsel for the petitioner that he had filed the writ petition before this court within the limitation as contemplated under the act to be filed before the National Commission. If that be so, we grant how much time for you to go to the National Commission?
Request for 30 days.
We grant the petitioner 30 days
Grateful.
to approach the National Commission. Thank you. The petition is dismissed as withdrawn.
Without any,
Yes,
it goes without saying.
The suffice to state, we have not expressed ourselves on the merit of the issue raised by the petitioner in this petition.
I'm deeply grateful.
So you want to withdraw this?
Lords, kindly allow us to withdraw with a liberty, my lords.
Liberty for what?
File a fresh, if in the case it arises, my lord.
We can only say that you want to withdraw it to seek such remedy as available in law.
My lords,
The learner counsel for the petitioner, after some submission, seeks to withdraw the petition to enable the petitioner seek such remedy as available in law. Dismiss as withdrawn.
Serial number 3. Yes, which.
I appeal for respond number 1.
Ma'am, there are 8, you appear for the appellate?
No, for the respondent number 1. The
Okay, wait.
petitioner has to.
There is no appearance for the petitioner. As a last opportunity, we grant 3 weeks' time to the petitioner to remove the office objections. If the office objections are not removed within 3 weeks, the petition shall stand dismissed without reference to the court.
Serial number 4. Sheikh Mali Patil.
I appeal for appellant, my lords. My lords, I'll complete the office objections today itself, my lords. Can it be taken at 2:30, your lordship?
The learner counsel for the appellant seeks and is allowed 3 weeks to to remove the office objections. Re-notify all. How many times have been given?
This is for the 7th time.
If the
My lords,
objections are not,
today itself I'll complain.
Pardon?
Today itself I'll complain, my lords.
do it.
Please.
Still give you 3 weeks. If
A
the-
date may be fixed, my lords.
You will give. If the objections are not cleared within 3 weeks, the appeals shall stand dismissed without reference to the court.
Please. May I request for a date, my lords?
We
110,
give you
110, madam. Serial number 5.
1st of October.
First of Oct- Serial number 5, Shri Murgesh Charity.
Here on behalf of the appellant, my lord, I am informed that the office objection. Single judge is only asked to consider why was the writ appeal filed by BDA. There is just a reason for that. I'll only point that out and my lord, then later on the matter.
My lords,
Only to
one-
that extent.
One humble submission, my lords. A copy has not been served upon me. I represent R2 in the matter.
Copy will be served, my lord, and can be done. Only just
Let the matter be taken.
Query, my lord, why BDA has filed it. Now, my lord, the learned single judge, my lord, says consider it. My lord sees the
Yes.
portion. Reconsider that's at page 39.
My lords, I appear for respondent number 2, my lords. I was the writ petitioner in the matter. My lords, I don't have a copy of the writ appeal, my lords. If submissions are made.
Yeah, we have heard you that. Just 1 minute. Yes.
Grateful.
Here, the lordship sees.
See, you may say, we are sorry. You may say that because the learned judge has said, keeping in view the observations made in the order.
Because what happens is, paragraph, if the lordship turns to page 32 and page 32, the lordship turns to. And paragraph 13 at page 31, the last few lines. Look, what happened was, before when earlier the single judge, my lord, had directed us to reconvey the land back, against which we filed a writ appeal. In the writ appeal, my lord, when the matter was pending, the respondent before your lordship, came up saying that let them consider our representation, we'll be happy with that. There, of course, my lord, the BDA, my lord, the representation was given and the honorable division bench, my lord, disposed of the matter considered. There, of course, my lord, small lapse on the part of BDA saying that we cannot even consider because question of giving TDR will not arise. That was not said, consider in accordance with law. Then, my lord, we said that under 14B of the Permanent Country Planning Act, TDR we cannot give because this is, they have to leave it, we don't have to pay them anything extra. So the learned single judge, my lord, cautioned the endorsement saying that since you did not take up that stand before the division bench, saying under 14B you cannot, so now you cannot take up. So virtually, the learned single judge, my lord, gives us the liberty to consider, but closes the option of passing an order only to that extent.
The observation need to be kept in mind and decide the representations.
Yes.
But are you not within your right,
Yeah.
considering the observations, possibly take a view which may not be in conformity with the observations? Are you not within your rights?
But what will happen is now the contempt has been filed, my lord, against this order. Then, my lord, then if you
My lords,
now
no, my
pass
lords, no
order-
contempt has been filed.
Sorry.
Okay. Is there no contempt has been?
Then I'm sorry, but I apologize. I was informed that contempt, then I apologize, but then I was wrongly informed of it. So, my lord, now if consider and, my lord, pass an order, that would then probably because, my lord, the observation stay on the point that on 14, if you lordship, my lord, just turn to page 32, para 14. That is the only difficulty in our thing. Otherwise, my lord, if your lordship gives us that liberty, my lord, then we will consider and.
No, but because if this observation you see at page 39
Yes,
of the learned judge,
yes.
TDS certificate in favor of the, in accordance with the law and bearing in mind the observation made by this court.
So, my lord,
Order expedition.
the honorable division bench had said in accordance with law. My lord, we passed an order in accordance with law. So the learned single judge, my lord, just for a moment, my lord, if the lordship takes paragraph 14 at page 32. My lord, page 32, paragraph 14, my lord, at the bottom, the last 4 lines, the bench will indicate that the submission made by the petitioner before this court, that it would suffice that if the representation was considered, was not opposed by BDA, which instead agreed to consider the representation in accordance with law. Lord, till this extent, my lord, it's fine. At that time, it was open for BDA to oppose the representation as well as the request made by the petitioner by stating that the petitioners were ineligible to seek TDR. Instead, the BDA categorically stated and submitted that it would consider the petitioner representing in accordance with law and did not choose to contend that section 14B20 rendered the petitioner ineligible to obtain TDR. So, my lord, now I have, my lord, rejected it on this ground. So, learned single judge says you could not have done because, my lord, even as a lot, my lord, lots of are not even in the mandamus unless they have a right to come. And I, my lord,
Just
so
wait.
BDA, my lord, I must admit before your lordship, my lord, BDA at that stage, seeing the representation should have pointed out to the honorable division that this also, even in accordance with law, we cannot, but we are ultimately called on to the court.
Just 1 minute, Mr. Kannur. Let's ask the counsel there. Now, you have heard the senior counsel?
My lords, I couldn't fully follow, my lords. My
Very
difficulty, my lords, was that I don't even have the writ appeal. I don't have a copy of the writ appeal since a year they have not served us.
We'll ask them to give you a copy of the writ appeal, then we will take it thereafter. Just give them, let them have a look also. You, so-and-so appears for the respondent, submits that the counsel for the appellant be directed to furnish a copy of the writ appeal. Full stop. The copy of the writ appeal be given to the counsel appearing for the respondent. Number
2, my lords, number 2.
Number 2. You appear for the other respondents. Respondent number 2. They don't have, they are not contesting 1 and 3. You appear for 1 and 3? 1. Is there any role of this Ruhad Bangalore Mahanagara?
Here they will not really be, but let them be on record. But
No, he is someone appearing for them. We want.
My lords, yes.
we'll ask the one of the standing councils to appear.
Full stop. Let notice be, full stop. Let, we say nothing on that.
Yes.
Just give a copy of the appeal. Just give them within 1 week. You have a copy, just give it to her.
Yes.
Re-notify, just give it in 2nd or 3rd week, September.
Okay.
26/9.
Grateful, my lords.
Was appear for the respondent, my lords. 6.
Notice. 26/9.
Yes.
My lords, serial number 6, I represent the official liquidator of the respondent company, my lords.
Who represents the appellants? You represent the appellant. Now, who are the other people, other parties here?
My lords, I am the respondent.
Acha, now you are the official liquidator for the
Company,
respondent.
yes, please.
Acha, what is the difficulty?
My lords, there is a new official liquidator that's been appointed.
Okay.
We need to brief him and take.
Have any
instructions, my
objection?
lords.
The counsel appearing for the official liquidator seeks an adjournment on the ground that a new official liquidator has been appointed. Full stop at his request, which is, the request is not opposed, which is adjourned to. Just give it.
October 1st, sir.
Grateful, my lords.
Pardon? Whose name?
Nick Krishnan, M.
Mr. Unni Krishnan's name be shown for the appellant in the cause list. Okay, just you say that the name of Mr. What is the full name? Mr. Unni Krishnan M's name be shown in the cause list instead of MB Naragund. He was okay.
7.
You appear for this? See, there is a notice has to go to the respondent. Let fresh notice be issued for service on the respondent. Just say Mr. M. Unni Krishnan appears for the appellant. Let fresh notice be issued to the respondent is not served. Let fresh notice be issued to the respondent returnable on.
1st of October, sir. Bill number 8.
Same Mr. Unni Krishnan? Same order in the
Senate. I'm on caveat.
Okay, you are here.
Well, sir, 2019 order has been issued directing them to deliver the property back to me. Till date, it has not been done. Today,
You appear for whom?
I appear for Joy of India, my lords. I don't have a copy. Respondent 1.
See, we have to issue. There are 2 and 3 are also there. Who appears for 2 and 3?
Only he appears. Well, lords, for me, my only issue is 2019, the month of September. We are in 2020.
We'll look into it. We'll look into it. So let's the others be there, 2 and 3. Just say that so and so appears for respondent number 1. The notice to respondent number 2 and 3 is incomplete. Let fresh notice be issued to respondent number 2 and 3. Returnable on.
110.
Next.
Lords, so copy of the petition be directed.
Let a copy of the petition appeal be given to the council appear within 1 week.
Lords, could I just request, my lords, an earlier date in the month of September, my lords?
Board doesn't permit.
110 is too long a date.
It's a matter of time. You will reach 110.
Serial number 9, government advocate.
Yes. R1 has refused. What about others? Where is the postal this thing?
my lord, I may be permitted, my lord, to appear, my lord. I undertake to file wakalat for R1 and R2.
You will appear for R1?
Yes. Undertake to file
He-
wakalat. Shri MS Nagar.
Also. Oh, this is 9. Say that though the office report states that R1 has refused the notice, the learned counsel appearing for all the respondents 2 to 4.
1 and 2, my lord, please only. 1 and 2, my lord.
What about 3? 3
Three
and
is
4?
already entered, my lord. Enter into appearance. Somebody have filed the wakalat.
Then who appears for 3 and 4?
Sir, 3 Shri Munraj Gowda, 2 and 4 served and unrepresented.
Okay. Who appears for respondent number 2 states that he shall also appear for respondent number 1. And wakalat shall be filed on behalf of respondent number 1
MS Nagar.
within 1 week, noting the said submission, re-notify the appeal on.
Fourteen 10. Serial number 10, Shiva Prakash. Serial number 10,
Yes, Mr. Shivaprakash. Non-filing of statement of objection response. You have not filed your response. Was the objection there before the learned single judge? We'll consider that.
A school was established in the year 2002, a well-reputed school, where after some time the management, the chairman and other person, because of their age, they did not run the school. One person during COVID period, he passed away, the Shah, which is the pioneer of the school. Then other person, they are because of age, and also 1 or 2 directors, they went to America to direct their children. Now the senior staff members and the teaching staff, they were assigned to run this school. Meanwhile, the landlord has filed a suit for eviction.
Eviction was taken.
Eviction order has been taken. During that time, management was they were not here. COVID period. The landlord has taken the order of ejectment. And in overnight filing execution, he demolished the building. There were about 316 students who were studying in that school. There are, to say, academically poor students. Next one was there's a second after the language speak. They demolished the entire school. We were put on road, streets. Then alternate building, we have made some arrangement and we started to run that school.
What is the effect of this interim order dated 26/12/23?
Interim order, they have taken the SSL certificate, they have taken examination, they have completed.
Okay.
Now,
But the result declared?
result also declared.
What happened to the result?
Result, they got very good marks and meritorious, they had previously in different schools and different colleges. And so far as 1 to 9 standards are concerned, because of the Karnataka Education Act, they are not permitting me to continue in that alternate premise. The reason is the amenities are not there and the infrastructure are not there and the field is required and other things, there are so many conditions they impose. That immediately I did not provide it because in the Bangalore city to purchase 1 acre of land or half an acre of land is close to 4 together. And we are the persons who are giving education to say underprivileged students and families. And we made a request that we request some more time. But the departments of education, they have rejected my application and they said it is unauthorized school that has to be closed. That's the stage we are now. Now, so far as
Candidates
predictions
are
of the government as per Karnataka Education Act and rules, they will not fulfill it immediately. We requested them to accommodate at least 1 year or 2 years, so that we can search out for a place where we can establish our school and we can run it. Even that also did not permit, and they said that it's another school, we have to close it, shut down the entire establishment.
See, we have to hear it.
Please, madam, please.
Because the order on 21-24 also says clarified direction shall not be construed as a renewal of recognition of petitioner institution.
Correct.
So we have to decide, then only we can take a call even for shifting also. You file your submissions, both of you.
Requires, hearing of.
Yeah.
I think what I seek, hands of the sample code, there is no time to seek and search out a place and establish it, because the students are there and there are unemployed students.
Like Mr. That's right, but today there is an order, it must not be construed as there is a renewal of recognition. So that need to be looked into.
Please. Please, I agree with you.
Though objections have not been filed, it is agreed by the counsel for the parties that they shall file written submissions along with the judgments, if any, within 4 weeks from today. Okay, file your submissions.
1510,
Thank you.
serial number 11, Narasimha Raja. 7.
Let's hear it. What does the affidavit says? Why did we call for that affidavit?
After the reinstatement, and because the order of dismissal has been upheld by the learned judge. And I submitted to your lordship the day on which the order was being implemented, that is, he was being reinstated, my lord, subject to the result of the expedition. And I had to relieve him, my lord, because the dismissal order was upheld by the honorable, by the learned judge. As on that day, my lord, he was involved in a case and he was suspended from service. Apart from that, he was involved in 14 cases after the reinstatement, pursuant to the interim order.
It was not suspended as per the instruction.
But I've stated so on an affidavit, my lord, and I have verified, my lord, I have the suspension order. My lord, para 4 I have stated, in para 4. On
But
3.
what is your stand on this? File your rejoinder. Additional affidavit has been filed by the respondent. Ilana counsel for the petitioner appellant seeks and is allowed 4 weeks to file rejoinder affidavit. You will file your affidavit. Can you file it in 1 week? We'll decide it. We'll have it after 2 weeks. Your 17B is there.
Order of dismissal was upheld, and he obtained the interim order on 3/10 itself, the order was implemented, my lord. He was relieved. And he submitted in the application, ex parte stay order, my lord. And he said that they're likely to relieve him. In fact, even that statement which he has made in the affidavit also is not correct, because he was on suspension on that day. The day on which he has sworn to an affidavit saying that.
But why did you reinstate him?
Hello?
Why did you reinstate
But
him?
it was pursuant to the interim order. But at all cases, my lord, wherever there is a stay, because my lord, we have a employee of 1 lakh, my lord, 1 lakh and odd, my lord. And it's a transport corporation, my lord, running under loss. And it becomes difficult, my lord, to make them.
See, we recollect in one of the matters, we have taken against you the fact that you have reinstated.
In fact, my lord, for that also I've produced the judgment, my lord, if your lordship, can I, because that also I find it in the counter, my lord, I think it's put up, my lord. That is the FX code, my lord.
Let him file this. We want a stand on those
Well, the apex court, my lord, similar case, he was reinstated and he was working for 9 years, my lord. The division bench was pleased to, my lord, uphold the order of dismissal, against which, my lord, the workman went up to the Supreme Court, my lord. The apex court held, my lord, that despite reinstatement order, my lord, since he was involved in so many cases, my lord, the order of dismissal has been. So
That
I
you-
have filed it, my lord, along.
That you may be right. Even after reinstatement, he was involved in this.
But what happens, my lord, in all cases, my lord, it's subject to the result of the writ petition, my lord. I don't condone his act, my lord.
Right,
And
ma'am.
instead of paying 17 wages, my lord,
But just imagine, after reinstatement, he continued for 10, 15 years.
It so happens, my lord, if he is, my lord, in that case, my lord, your lordship took that view, my lord, because he had not involved in any case. A statement was made, my lord. That
Obviously.
was the point factor, my lord. But if he is involved in any other case, my lord,
That's not a thumb rule. We are not saying so.
Yes.
We will surely see his conduct thereafter. We'll just file a rejoinder
in
affidavit.
fact, my lord, there are so many, my lord, one more submission I want to make. Whenever there is a reinstatement, my lord, even if the, if I have a good case also on merits, my lord, we ourselves, my lord, get the instructions from the corporation, my lord. If they are not involved, from additional, my lord, the punishment would be imposed and we close the case at the stage before the learned single judge itself. It will not reach your lordship, my lord. We won't see that, my lord, it will reach the division bench. But there are some matters, my lord, where
Obviously.
they are incorrigible, my lord, we had to take a call.
Trying to land a reinstatement. But even sure the state and the exam parties, they have to accommodate 17B.
See, that's the reason they say in lieu of 17B, they want that they should use your services. So they take you back.
At least not the direction to reinstate, pending consideration of this one, because it was the judgment of the learned.
Right. That's the reason we are saying we'll put it for after 2 weeks, we'll hear it. Okay? Yes.
11-9. Serial number 12, Shri Sudarshan. 12.
Ma'am, what still remains in this? This was, just show us. No, we just wanted to know, possibly you will take instructions. This order has been passed. On an interim relief. That's right. You just take instructions. And this was with respect to certain examination which was held for the first year of GNM course in December 23. Either they have participated in the exam, they have become infructuous. Take your instructions. What do you say? Concluded, but have they appeared in that? This is filed by the board, I suppose. He must have this. The Nursing Medical Education Authority. That's right. Who appears for them? And you appear for whom? State of Karnataka. What do you want? We'll have it after 2 weeks. The request of counsel for the appellant re-notify, but you must take your instructions.
10-9. Serial number 13, Shri Shekhar.
The question is not that, but kindly come to page 15, my lord, in page 15. The order of the learned single judge, my lord. Kindly see, my lord, the para 1, my lord. But so and so learned counsel for the petitioner who has appeared in person. As could be seen from the daily order sheet, the concerned caption for the petition was listed on 3/10/23. On that day, at request on behalf of the learned counsel for the respondent, the petition was ordered to be listed on 4/10/23, subject to payment of cost of rupees 1,000 to Advocates Clerk Association. High Court of Karnataka, Bengaluru, and it was made clear that the respondent will not have the right of audience only if the cost is not paid. The petition is listed today. When the matter is called, there is no representation on behalf of the respondent, and the cost of rupees 1,000 is also not paid. If we consider the facts. My lord, he was not heard, my lord. And this, after this, my lord, an application, even no effort is made, my lord. It was by a different counsel. Now, even for my learned friend to say, my lord, the learned single judge has heard, he is not, my lord, participated, my lord, in the proceedings before the learned single judge, my lord. And para 5, my lord, is the explanation in the appeal memorandum, my lord.
Yes, what do you say?
Date of hearing, my lord, not accepting the document before the commission, my lord, one day, my lord, is start for project, start for them.
We will hear you now. Make your submissions. Yes. What is the challenge to the, you proceed on the basis as if you are arguing a writ petition, but though they have to argue, but you will set up your case, the respondent's case before the writ court. You're appearing for the employee, na? Now let's see the order of the tribunal, labor court. Come.
While false case, as if we do not reach the target. There also have the case charges in the disciplinary proceedings. In order to strengthen this person, the authorized representative of the first party last mentioned the fourth, people coming 15-20. These documents evidence that the second part of the document is an initiated disciplinary proceeding against the sitting inspector for the misconduct of not reaching the target. In your please documentary evidence, the works of WW cannot be good, probably accepted as due to pressure. In order to reach target, the sitting inspector will use to book case and release the conductor like first party of the. Further, from the works of WW is evidence that sitting inspector while false case and not followed the procedure etc. And procedural exhibit M1, it is evident that there are no words used as first party conduct case. The desired intention to create the corporation, not issue the case. This exhibit M1 reflects that 2 tickets were not issued and not received the case. The first party not at all calculated the amount. There is no desired intention. The first party is giving the second party calculation. Further, exhibit M5 reveals that the second inspector inspected the vehicle at commissary stage. In place, column Ojikodu is mentioned. If you consider the South Indian banks of commissary situated within Ojikodu, that means the commissary comes within the city of Calicut. In this case, the earlier business transit traveling from Calicut to
Bangalore, Calicut.
Bangalore, the bus was checked immediately after within the jurisdiction of Calicut. And they are still trying to issue the tickets, and even before reaching the state part, they checked the bus, it's a contention get them made. that has been answered by the labor court, my lord. Was it called, Damascene comes within the jurisdiction of, was it called, town. And next stage is, Lordship will tell you, Damascene comes within the jurisdiction of county. Thus, it shows that checking inspector checking the bus before reaching the stage. As per exhibit M2, the stage is culpet. Hence, from these facts, one can gather that the checking inspector with the bias is indicated, checked the bus before the stage. And there is a place, column of exhibit M12, the target given to the person who boarded.
But where is the rule that he should only check it on the stage? He can't do it in between? Where is the rule to say that the checking inspector must check a bus only at a particular stage, not before that? Where is the rule?
Not like that. Like, yes, my lord. Before reaching the stage point, when come, normally, my lord, this will be checked in the stage point.
Why should we say so? It should be checked at the stage only, not before that.
There is a standing order with circulars of the corporation.
No.
Check the bus in the stage point.
My lord, sorry.
My lord, we have to show the stage in the lord before reaching the stage point.
My lord, my lord, can I clarify, my lord? My lord, they can check at any point, my lord. They can check at any point. Only thing is, my lord, they should not charge him for not having closed the way bill. Way bill has to be closed only at the stage entry, my lord. But checking can take
There
place.
is another reason also. Suppose I board a bus at particular stage. Before it reaches the next stage, he would be in the process of
My
issuing
lord, in
tickets.
between the stages, there will be many stops, my lord. There will be many stops in between the
No,
stages.
when you are talking of stage, are you saying stage is Bangalore and Calicut?
My lord, no. Stages, my lord, would be about 3 to 4 kilometers, my lord.
Where the
And in-
bus will stop?
But in between that, my lord, there'll be stops. So there is every possibility of the passenger getting down, my lord, in those stops.
Right.
So
For
therefore,
reason, when a passenger boards the bus,
yes, my lord. He
he
has
should
to
be
issue
issued
tickets.
tickets.
Yes.
But that must not be construed to mean that, look here, he has boarded, but you have not issued ticket. He
Yes,
said,
ma'am.
I am on the verge.
I can charge him, my lord. I can charge him for non-issue and non-collection of fare, but I cannot charge him for not completing the way bill. There's one more aspect, my lord. In the way bill, he has to complete the entry of the passengers, my lord, up to that stage.
Up to that stage.
That I cannot charge him, my lord. You have not completed the way bill. That I cannot charge him for having not completed the way bill.
Why can't you charge him?
Because, my lord, he will have time to enter the way bill, my lord, to number of passengers. But as far as ticket is concerned, he should issue the tickets immediately. And here, my lord, what has happened is,
And that's the charge here.
yes, and there were only 17 passengers in the bus when the bus was checked. 17 passengers. And he had, my lord, what it says is the total passengers in the bus was 17 passengers. He had not issued tickets to all the passengers. 17.
Wow.
The chart says, my lord, sorry, one second, my lord, I'm sorry. My lord, in a group of 2 persons, my lord, were traveling in a group, my lord. I'm sorry. 2 persons were traveling in a group, my lord, from Bangalore to Calicut.
But tell us one thing, how 17s would not be issued tickets?
Not
It
17.
would be so glaring, you know.
My lord, it's not 17, my lord. Sorry, I stand corrected, my lord. There were 17 passengers in the bus,
Right.
of which he had not issued tickets to 2 passengers. So he cannot say, my lord, that the bus.
Right, we are surprised for all 17 years not issued
Sorry,
tickets.
sorry, my lord.
That's something very glaring. He
No, no,
could
no.
not do it.
No, no. There were 17, I'm sorry. And, my lord, what the chart says is that on 6/7/2013, the bus was flying from Calicut to Bangalore. And the bus was checked, my lord, at Tamarassery. And it was found that, my lord, there were 17 passengers, of which 2 passengers traveling in a group from Calicut to Bangalore were not issued with tickets of rupees 485 and not collected the fare.
Yes, ma'am. See, but we are unable to understand these observations of the labor code, bias. Why will a checking staff would be biased? They are doing their duty, taking the bus. But how can they presume, the labor code presume that they are biased?
Then we put a understanding order. The effect that the checking inspector shall detect the number of cases, remark cases, outstanding remark cases, and they have to report the condition that were
Otherwise, they will punish you. They will punish the inspector. That's the reason that they charge it against the conductor even before it is required. But if they not reach the target, they issue an article of charge. And
But is it your case that you have issued tickets to all the passengers?
they are still time to issue, but very case that before reaching travel series, I was issuing tickets who have boarded the bus at Calicut. But the checking stamp of check, which has been accepted by the labor court. That the resort I submitted the reply to the article of charge.
Let's see, let's read further.
The labor court court that the other things are justified and ordered for reinstatement. May I read other
You have the record of the inquiry, labor court.
Yes, yes.
Is the labor court record here? See, his case is even the ticket checkers were under pressure. They have their quota.
It's
So
not,
for ensuring that quota is achieved,
it's not.
right, left, center, they also
Not
keep
so,
on
my lord.
going.
What the checking officials would do, my lord, they just take the vehicle, my lord, they are provided with the vehicle and they would go elsewhere, my lord, without checking them. As therefore, my lord, to put some data, my lord, it has been issued, my lord. It's not that they cannot use it, my lord. He has to argue on the merits of the case, my lord. Here is a case, the bus was checked, my lord, to show that it was not, it was checked at the place where the checking officials stated, my lord. It is evident from
But
the.
do you record the passenger statement?
Yes. Ma'am. In a case of non-issue, non-collections, my lord, the statement of the ticketless passengers is not recorded, but penalty receipt is issued, my lord. The penalty is imposed, taking into consideration the place of their boarding and the place of their checking, my lord. And that will prove because it is attested by the workman. The penalty receipt is adapted and on the offense memo is issued on the spot, my lord. They don't reply to the offense memo immediately. It's not their case which they make out immediately, my lord. Only at the time of charge sheet, which is about a month later, my lord, they come up with this plea. If it was the exact case, my lord, they should.
So is there anything which is taken from the conductor at the spot in this case?
Well, that is, he had not issued the ticket and not collected the fare, my lord. That's the charge.
But those passengers who were traveling without
They
ticket,
were paid, they were levied with penalty of 10 times the ticket fare.
where is that penalty evidence? Where is that evidence?
I'll just pass on.
How many passengers were imposed
Two,
penalty?
Two, my lord. Two passengers.
Where is the penalty issue, this thing, reference?
Exhibit M4.
M4.
May I pass on?
Shows the.
Sorry, my lord, it's in Kannada, my lord. It's in Kannada, my lord, I'm sorry. Issue ಮಾಡಿದ್ದಾರೆ. Penalty ಇದೆಯಾ exhibit? My lord, the conductor's signature will be there, my lord, on the left hand side, my lord.
This is on the date of the misconduct,
Yes, madam. On the, at that time, madam.
same spot.
Spot, madam.
How would you explain this? Yours. Yes.
Before 1 kilometer behind, why they have just showed their hand to come to Bangalore. At that time, bus was empty. The transport is person, the calculation is the manipulation, because the ticket value is the question. The total holder will come to last week. And I have permitted to set the handles to go to first. Here the other tickets is value. What is the first we are compensated? And we get that 4 handles, what is the first compensated? And we should take it to just the commentary. The second job also shifted the bus, the commentary, and explained the circumstances in which the passenger was at the bus. But the second job not considered and also the passenger forcibly obtained the 970 ticket from me, the force. After obtaining ticket from me, until that I am not issuing ticket to passenger traveling to Calicut to Bangalore. The two passengers not traveling from Calicut. In fact, along with these two passengers, 3 more passengers boarded the bus along with these persons. And permit may be issued ticket to those 3 passengers. But remaining 2 passengers are concerned. The second stop, Paltier will that the ticketless passengers traveling from Calicut and Paltier will be offense amount. And in that offense amount, cannot receive number and filed state that from whom the penalty amount was obtained. And failed to state that from whom the penalty amount was obtained. I submit
But
that.
see, the fact is that those passengers have been imposed penalty.
Submit that there is 2 ticketless passengers traveling from Calicut. In assuming that there is 2 ticketless passengers traveling from Calicut, however, it is not specified that the said 2 passengers travel without ticket. At best, the ticket stop may alleged that the ticketless passenger traveled up to Tamaseri. There's some techniques similar to Tamaseri. From Calicut to Tamaseri, they are not having tickets. The second stop at best, alleged that not having tickets from Calicut to Tamaseri. Not at Bangalore, he made the ticket at Tamaseri or not.
How much was the ticket cost from Calicut to Thames? To Thamesari, how much is the cost?
10-15.
That's right, but 485 is to Bangalore. And they have charged at 485. They have, see, but they were traveling to Bangalore.
But they are traveling to Bangalore, but the bus was checked out Tamaseri.
You are right. You are right. But surely before Thamesari, they should have been issued tickets.
Well, because of Malad, they boarded up at then Malad, I want to close some tickets, Malad. I am unable to issue a ticket, that is my explanation, Malad.
How much is the distance between Calicut and Thamesari?
Malad, my explanation is that there is 1 kilometer behind the Tamaseri, Malad. 4-5 passengers showed their hands to board the bus, Malad. I allowed them to travel the bus, Malad, and most of the issuing tickets, Malad. Considering that these passengers are boarded the bus at Tamaseri, by the time check was conducted. That is my explanation offered in this charge, Malad.
See, if the passengers had an objection saying that they were not traveling ticketless or they were yet to buy the ticket, because they boarded the bus only at a short distance, then why should they pay the cost penalty?
It's 30.5 kilometers. Distance of 1 hour, 30.5 kilometers. The Google search.
Who gave the penalty? You or the passenger?
They have collected penalty from me, I explained my lord in this.
How could you?
No, I have not collected. That's his explanation. All conductors, my lord, they say that. They say that, my lord. All the conductors, my lord. If your lordship could see all non-issue of tickets, my lord, and all the reply, my lord, they say that they have paid. My lord, that is to deter the passengers, my lord, not to travel without the tickets, my lord. They have been issued, my lord, with penalty, my lord, just to deter them, my lord. And that's the reason, my lord, a responsible, my lord, passenger would demand ticket, my lord, while boarding, when they pay the.
Yes.
Even after compensation also, early ticket prices cannot be treated as ticket prices. The cities are just to statistical purpose, and this is the target. Taking advantage.
How much is the distance between Kochi and Tamasari?
No, no, it says 30 kilometers, 30.5 kilometers.
30.5 is a huge distance.
And 1 hour.
They did not travel from Calicut. They boarded the bus 1 kilometer before the commissary. They are accepted with the labor code. And in another issue, they require to obtain to address the passenger plan. If they address plan, I have examined the inquiry.
Now, was the inquiry held to be fair and proper? Then tell us one thing. If it is held fair and proper, the basis for the labor court is only to say that based on the evidence before the inquiry officer, can it be said this is a perverse? Or can it be said it is bias? You know, all those things which have come on record. What is the penalty imposed?
Well, in fact,
After the award, for 5 years.
He has been reinstated.
no, no.
He has been reinstated, man.
Yes, madam. Subject to the result.
For
of
how
the
many
examination.
years?
But, he was reinstated, my lord, in 2019. 19.
Any misdemeanor
But
thereafter?
I'm informed, my lord, that there was a case, my lord, red mark case against him, and findings has been submitted holding that the charges are approved. my
What
lord.
are the allegations there?
Non-issue of tickets. Red mark case, my lord. Red mark case is a serious case, my lord. They have classified, my lord. This becomes a red mark case, depending upon the amount and the number of passengers and
That's the solitary case?
no, 15 cases.
Even thereafter?
No, the previous, my lord. At the time of
But
dismissal,
after reinstatement, how many?
after reinstatement, my lord, one case. My lord, I have no information, but what they have said, my lord, is that he was subjected to inquiry and findings have been submitted. It was at the stage of submission of findings, my lord. And at that stage, the dismissal order was upheld by the learned single judge.
Where is it pending? The recent misdemeanor?
My lord, what they have stated is, my lord, he was involved in a red mark case, and after the reinstatement, my lord, the inquiry was held and the charge is held to be proved, and findings is submitted and pending for final orders, my lord.
What is the charge against you? No, you must be knowing it. You know, you may not be knowing it.
Probably he did not appear in the, for the workman, my lord. It's a different council.
All right.
Probably he will not be knowing. That's what I'm supporting, my
No,
lord.
no, we are only on this.
Yes.
Does he know this? You will just adjourn. We want to know what is the outcome of this. The latest misdemeanor.
And my lord, what happens, my lord, I only request your lordship, my lord, in all such cases, my lord, wherever there is an order, my lord, of reinstatement, I'm bound to pay 17B wages, my lord. And in such cases, my lord, subject to the result, I repeat, my lord, subject to the result of the writ petition, my lord, they've been reinstated. Kindly, my lord, I request this honorable court, my
You're
lord.
right, you're conscious.
My lord, what happens, my lord, because they have been reinstated, my lord, because we have a lakh and 60,000 employees, my lord, altogether. And to pay them, my lord, 17B wages, and it is running, it's not under profit basis, my lord, because it's the only transport, my lord, because it's monopoly, my lord. And the transport service is being, my lord, offered, my lord, at a reasonable rate, my lord. So, and therefore, my lord, taking into consideration the financial aspects, my lord, we take them into service.
We are not taking it.
We take them into service, my lord.
We are not saying anything.
Because it's.
We will hear you on this.
It's
We are
only
conscious.
disturbing, my lord, because that should not be held against us, my lord, because that's an arrangement made, my lord, instead of payment of 17B wages.
You're right, you're
Please,
right.
my lord, I request, my lord, because
We will hear you on that, but we want to know, we are curious to know what really happened thereafter. If ultimately there is a misdemeanor thereafter, possibly.
my lord, even then, my lord, even, my lord, if on facts, my lord, if your lordship could take a decision, my lord, on the facts of the case, my lord, here is a case of 17 passengers and 2 passengers, my lord, were not issued with tickets, my lord. And it's amount is, my lord, is amounting to 800, more than 800 rupees, my lord. If I had not checked the bus, my lord, those passengers would have gone, my lord, without tickets. And ultimately, my lord, it's a. Therefore, my lord, my only request to your lordship, my lord, is please don't hold, my lord. Because, my lord, reinstatement, my lord, my lord, your lordship could take a decision, my lord, on any issue, my lord, but not on this, my lord, because every day, my lord, there is reinstatement order. That's the only, my lord, because if your lordship is mounting the relief, my lord, I have no say.
We
But
have not.
But not on this count, my lord, that he's been
We are
reinstated.
just only hearing him. We
Yes.
want to know what happened in the next.
Yes, I'll,
That whether any final decision has been taken, if yes, what is that?
yes. No final decision is taken, my lord. By then he was dismissed. That they have written it to me, my lord. But that's the only request, my lord, because it's worrying us, my lord, because even today, my lord, we have taken before the learned single judge.
Yes, ma'am.
Yes.
You say that, we have heard the learned counsel for the parties for some time. During the course of the hearing, it transpired that after the reinstatement of the appellant, he has been issued a fresh charge sheet. The learned counsel appearing for the respondent would submit that the findings of the inquiry officer on the charge sheet are under submission before the disciplinary authority. To stop, appropriate shall be that she shall take instructions as to any final order has been passed by the disciplinary authority on the said charge sheet. Okay, re-notify on.
Five nine, madam.
Which now, which date?
5/9, sir.
Okay.
Serial number 14.
Yes, Mr. Raghavan.
No, there are a few documents.
You have not filed it?
No, we also have to file, they also file. State one.
It shows this, no?
Not a complaint is lodged before the land grabbing court in respect of certain lands belonging to the government. No, I'm just saying what the matter is about. It's coming up before. I am the complainant whose
Yes,
complaint
yes, go
has been-
ahead, go ahead.
A complaint is lodged before the land grabbing court alleging that the petitioners, who are the respondents before the land grabbing court, have appropriated 16 guntas of government land. The learned land grabbing court passes an order at annexure B, which is impugned in this writ petition at page 69, saying that don't alienate or encumber that land pending disposal of the inquiry by the land grabbing court. They are now before this court. They have obtained a stay of the proceedings before the land grabbing court. From 1 year, we are in limbo before the land grabbing court. Whether your lordships would hear this entirely or whether it would be sent back there, that's a question that your lordships would decide. That's all the only.
What do you say, Mr. Raghavan?
The question is not why I call me for your lot of conditions. With respect to the same 16 laws of land, the constitutional court law has already used my in this court. Writ petition filed by me has been allowed. Writ appeal filed by the state has been dismissed. Now, one of the prayers that I have to also consideration is whether a tribunal of limited jurisdiction can now pass an order in respect of a matter which is already concluded by 2 orders passed by constitution. Now, that is the question, and this is not a court of unlimited jurisdictions. This is a tribunal of limited jurisdiction. So therefore, I will demonstrate with reference to the provision of the statute that this can never constitute land grabbing having regard to 2 orders passed by the Honorable Court and at the instance of the state. The state cannot file an appeal. I tell you also what happened, bro.
But tell us, Mr. Raghavan, why not the court, special court, land grabbing court?
Same thing.
Will consider all your pleas, including this? Why?
If you also, I take it also to the provisions of the statute. Unless it amounts to land grabbing, they cannot go into it. And when it is not land grabbing, has been determined by the Honorable Court.
That's right. So the final conclusion will be there is no offense.
No, that's not. We can also see the provisions of the statute. So this is not like a civil court, where as long as it is a civil matter, unlimited jurisdiction. No, the jurisdictional aspect of the matter, so far as land grabbing court is concerned, is that there should be land grabbing. And if it is already concluded by a constitutional court, maybe you are not just. I asked myself, there is somebody going to it. And whose instance? At the instance of a public spirited person. When the state themselves have lost a case before the High Court. But this is can't be misused. That's the reason why there is 227 jurisdiction. 227 jurisdiction law can be exercised in several circumstances.
Yes, ma'am. But tell us one thing.
Yes.
In a case where there are allegations of land grabbing,
Yes.
what is your best defense? Your best defense is this only.
No, but in case there are allegations of land grabbing and that issue has to be decided by the land grabbing court, I will have to go before that. But if it is already decided by this court, I ask myself the question, where is the petition going before the land grabbing court? And those documents were before the land grabbing court filed by the petitioner who claims to be a public spirited person. No, there is no personal interest of the complaint is concerned. The state filed an appeal before this, but I think also what's happened.
But I was not a party to those proceedings.
Just 1 minute. The land is the government land.
Yes.
What happened, 1975. Land was granted to the same land. That was in 1975. Then, my lord, at the instance of certain persons, and I don't give also the details of it later, if necessary. Then, a show cause notice was issued to me saying that I am going to cancel the grant. And that show cause notice was issued in 2022. 2020. That is after a lapse of over 45 years. We challenge the proceedings, we challenge the show cause notice issued to this honorable court. During the pendency of the show cause notice, order was passed cancelling the grant. That also was questioned before this honorable court.
Grant is of the same land.
Same, they ditto, no doubt about that. And my explanation was allowed. The show cause notice and the order that has been passed, both were quashed.
Stating
Stating that this could never have been done, this action could never have been taken.
for issuing a show cause notice for cancellation of the grant.
Both were quashed. As is that, a writ appeal was filed by the state. Writ appeal was dismissed, and when a prayer was made saying, please permit us to take any other action that we can take. The court said, no, I will not permit you to do anything. The whole thing is dismissed. And now, a person who claims to be a public spirited person files a bad, interestingly, refers to all this. And I tell you also not separate. All this at the instance of, because what happened is this, between the petitioners and a developer, they call it joint development with respect to this property and adjoining properties, all of which we were the owners, but not for the purpose of developing the market. A dispute about the respect. That matter, my lord.
We'll just look into it. But what is your basis for land grabbing?
My lord, as far as the dismissal of, as far as the allowing of the writ petition and the dismissal of the writ appeal, both those facts have been brought to the notice of the land tribunal, land grant tribunal.
Right,
At the time,
yes.
I have not suppressed anything.
No, but-
No. The complaint is filed on the basis of additional material that has been produced before the land grabbing court. So it's not as if that the same material is rehashed for that purpose. One.
Now tell
Second,
us
your
what-
lordship would say, I am not a party to the proceedings before the earlier round of writ petition and writ appeal.
But
Thirdly,
state was there.
state was there. Third thing is the state has filed a review petition against the division bench dismissal, which is still pending. The review application is still pending. No, fair enough, but I'm saying it's still pending. This
So you
court is
will-
seized of the matter.
We will hear it, but you will file your translation.
Yeah. Some date may be fixed, my lord. There is a peremptory order that was passed last time also on 3/7 that they are bound to argue. They've got to stay. They are not interested in arguing.
But the law has, I think, much water is flowed in the bridge with respect to maintenance of the petition. There are two judgments of the Honorable Supreme Court.
We'll see.
The later judgments of the Honorable Supreme Court were saying that existence of a remedy otherwise is not a bar to the court going into it on the basis of facts of each case.
That's right. We are right. Let's assume for a moment, you can argue. There is no offense made out in the given facts, which are admitted facts, that you can argue. But he will say that if there is something more that need to be looked into, that he can argue.
There is nothing, all that is happening at the instance of a tahsildar, the notice was issued, and that there are at least half a dozen proceedings pending before this court with respect to notices issued, all of which have been stayed, all of which have been quashed.
The Mr. Raghavan and a senior counsel appearing for the petitioner seeks and is allowed how much time? Weeks. 10 days time to file the English translation. English translation. You have to file also.
In the same 10 days, my lord.
Very well. The learned senior counsels appearing for the parties seeks and are allowed 10 days time to file English translation of Kannada documents. Okay. You have to file anything, state.
It has not the case.
Pardon? The objections. No, but you have filed it. Objections.
Yes, I have filed. I have filed.
State.
In fact, in my statement of objections, there are some vernacular documents, but I will see that it is.
We want only translation.
Pleadings are complete. Pleadings are complete.
No, they want to file it. You want to file it. Full stop. Additionally, as requested by the council appearing for the state, objections be filed within the same time period. Okay, re-notify the petition for hearing on. Additionally, we will say this to both the councils, that additionally the party shall file also
Sign
their
offs.
written submissions. Written submissions along with list of dates and judgments in support of their case.
Some date may be given,
We'll give you date.
Sir, 4/9.
4/9.
Can it is the second week of September, my lord, usually only this, in the wedding in the family, and I happened to be
Yes.
the mama, my lord, of the bridegroom. Mama had the word to play.
Yeah, right. Give it.
10/9.
After.
9.
After 15.
Sir, 13/9.
13/9.
13/9, sir.
Okay, thank you.
Okay.
Serial number 15, Shri Nagendra Naik.
Notice to respondent number 2 and 3 is incomplete.
File memo, withdrawal.
You want to withdraw this?
Second, sir.
You appear for the petitioner. Then memo for withdrawal dated 5/4/2024 has been filed by the petitioner. Just give us, just take that, ma'am. Which reads as under. The learner counsel for the petitioner reiterates the prayer for for withdrawal of the petition. In view of this, in view of the above submission, the petition is dismissed as withdrawn. Just see the IAS. Next.
Serial number 16. 16 also.
You filed? You want to withdraw this? The learner counsel for the petitioner. Learner counsel for the petitioners has drawn our attention to the memo for withdrawal dated A1/8/24, which reads as under. She reiterates the prayer for withdrawal of the writ petition. Accordingly, the petition is dismissed as withdrawn. Pardon? Liberty to? Okay, which reads as under. She seeks liberty to file a fresh petition. Noting the averments in the memo for withdrawal, comma, with liberty to file a fresh petition in accordance with law. Petition is dismissed as withdrawn.
Much obliged.
17. This one.
Okay, for appellant in this case.
For the third respondent in this matter, minutes. In
Yes, Mr. Shankar.
I
What is
sought
this?
an adjournment in respect of serial number 17, my lord.
For 17.1, who appears, Mr. Ravi Shankar? 17.1, there are certain, because both have been clubbed.
both have been clubbed, minutes.
And there
But
are
the council appearing for R3 can also take notice for R20 in 17.1.
Because we find that quite a few, 5,
Yes.
17 to 13, the notice is not.
That
complete.
notice I have taken, I will file a wakalat. It is taken.
They can file the comparative table in both the petitions so that the respective
Yeah,
councils
You
could be.
appear for 17.1 also?
17, my lord.
17.1 you appear.
I'll take steps against the.
Yeah, we find that service in writ appeal 684/2023 is still incomplete. Let fresh notice be issued to respondent 5, 7 to 13, 17, 18, and 20. Returnable on.
May I just,
Unclaimed loan. Respondent 90 is unclaimed.
Who, the 17?
Respondent number 19.
19, very well, we are not considering 19. Yes, Mr. Ravi Shankar, tell us.
Lords, the respondents in the companion writ appeal or the parties in the companion writ appeal are also the parties in 17.1. They can file a comparative table so that the respective councils, because we are,
That's the best.
instead of,
If the common respondents are there, we take your appearance in the other appeal also,
Yes, my lord.
except those who are not represented here. You're getting the point?
Yes, my
Do
lord.
you now appear for respondent 5, 7 to 13 in the connected appeal?
No, my lord.
You don't
We not.
appear.
We not.
Neither for 17, 18 and 20?
they are also
Myself,
the
I
parties.
only-
If your lordships were to pass it
Represent
over,
four.
I'll file a comparative table, my lords, of the rank of the parties in the writ appeal 17 and 17.1, my lords. Because the ordeal of duplication of service of notice, my lords, could be.
You're right, but just see this.
Respondent number 3 is busy in 17.5.
Respondent number C.
ಎಲ್ಲರೂ ಒಬ್ಬರೇ parties.
4 to 7.
ಕಾರ್ತಿಕ್, ಹೇಮಾವತಿ, ಕೌಶಿಕ್.
The counsel for the appellant in 684/2023 shall also take steps in respect of deceased respondent number 3.
ಎಲ್ಲರೂ ಅವರೇ ಇದ್ದಾರೆ.
Full stop. But you don't appear, you are not briefed in the other, for the other respondents?
Lords,
In the connected?
I'm
No.
briefed only in respect of respondent number, that is R3 BC Ravindra. In the first writ appeal.
Is he common respondent for in both?
He is a common respondent.
But-
He is R20 in the connected matter.
Oh, R20. Because there is one R3 who has expired,
I think it's in 17.1.
17.1.
Lords, R3, he is only 24 years. He is still appearing. He is before the court. R3 in the first appeal, Lords, it is shown as BC Ravindra by his LR, Shanmukh. Ravindra is dead and his LR is already on record.
Ravindra is there. Ravindra is the purchase.
But in R3 in 17.1 is different person.
He is
A
different
different,
person.
yes.
He is a different person.
Yeah.
BC
Maybe-
Ravindra by R Shanmukh is R20, my lords, in the connected matter.
Just find out, you have to work out this.
Yes, your lordship.
See, there should be clarity. Returnable on, just give a date, man. And
Even
you must
comparative
take
table,
instruction, Mr. Shankar, you also, the briefing council must take instruction where there are common respondents at least.
Lords, I was just running through it. Most of the respondents are common respondents in both the matters.
That's right. Just give it date.
25/9.
Please, my lords. Lords, I'll just file because could it be a little shorter date, my lords, of course, subject to.
The board doesn't permit, Mr. Shankar.
Eighteen urgent. Serial number 19, Shri Vedamurthy. 19. Serial number 19.
Pass over. Continues this.
20. Serial number 20, Srimati Renuka.
Pass over.
21, Shri Munidas.
Appellant by me in this matter, my lords. The petitioner's property is subject matter of an industrial layout found by the KIDB. The acquisition proceedings was initiated in respect of so many other properties, but reflecting them as government lands. So there was no formal acquisition as such. It so happened that the petitioners who are granted with the lands, their entries came to be discontinued in the year 2000, 2001, when there was a computerization of the revenue entries in Karnataka. So then there were proceedings initiated under section 136(3) of the Karnataka Land Revenue Act to find out the genuineness of the grant and the entries. There were entries prior to 2001, 2002. These are the handwritten entries from 1965 to 2001, 2002. Deputy Commissioner passed an order in favor of the grantees, saying that they are the grantees and their names will have to be entered in the revenue records. Now, in respect of the very same survey number, there were different blocks of properties. In respect of about 4 to 5 blocks, the KIDB issued a fresh notification, determined the compensation afresh in accordance with the date of the notification, and has passed an award. Now, the learned single judge directs that the award should be computed at a particular rate, which is not the rate at which it is given to the neighboring land, or rather the same survey number, number 1. And even the learned single judge says it should be, the interest should be computed from a particular date for which there is no basis. Notice this, in respect of this very survey number, which is an adjoining piece, the matter again traveled on a similar order of the learned single judge before this honorable court. KIDB considered that they had in fact taken possession of the property on 21/11/2008. So this honorable court clarified that the rate of interest should be paid from 21/11/2008. So that issue is set at
They
rest.
are not in appeal against this order.
They are not in appeal against this order. Notice they have already prepared. Notice what happened after the orders were passed by the deputy commissioner. They started the process in respect of all other properties who were similarly situated. For those properties, they issued notifications. Even for my property, they corresponded internally saying that since I am situated similar to those to whom the compensation has already been disbursed, my case also has to be treated similarly. So a checklist was prepared of all the necessary documents and a draft notification was published. It is at that stage there was a standstill, as a result of which we came before the learned single judge. The learned single judge says that it should be computed at a particular rate and it should be taken from a particular date. So these are the two aspects. With
What according to you is the rate and what according to you is the cutoff? You said 2008.
2008. That now it is set at naught minutes because the KIDB considered that the lands were taken possession only on 21/11/2008. That is recorded by an order of the coordinate bench minutes. May I just pass on this order?
Just show that.
May I just, this is in another matter, my lords. Argun copy kudi.
What is the date, cutoff date here?
Lords, the date which is given here is 2015.
16/6.
16/6. Lords, may I kindly see the coordinate bench
So
out?
that's one thing, Mr. Will not the date of possession maybe in this case was taken in 2015, not.
Lords, it's under a common Mahajan, my lords. The entire property, this is a common property. This is one entire single survey number. All the properties consisted in this survey number were taken possession of on the same date.
Same date.
Same date.
The possession chart, the possession.
The possession chart is in respect of one single survey number on the same date. That there is no dispute.
Proceedings must be there, no?
Yes, there are proceedings. My lords, I have produced those proceedings also. Now, these are the only two things. Only one thing, if they have already taken steps to prepare a draft notification, and if similarly others situated as that of the petitioner, they have determined the market value by virtue of section 30 of the KAD Act, which now makes it mandatory for the awards to be passed under 2013 Act. Section 73 of the KAD Act says, of the 2013 Act says, that there can be no disparity. If for any reason a lesser compensation is awarded, which is pari materia with section 28A of the 1894 Act. So now the law is well settled that whatever is the neighboring land's compensation should be awarded to me. That's all what I am asking. I have produced documents to show that the neighboring lands have been awarded and compensation is already dispersed. The one which I now passed on to your lordships, my lords, even in this matter, pertaining to same survey number. My lords, here also para 2.
Here also it's 2015.
Yes, the very learned single judge had directed, my lords, that it should be fixed from 16th May 2016.
But the only difference is this, Mr. Ravishankar,
What's
that's, this order, impugned order is much before this order was passed.
Yes, my lords.
This order was, this is
That's true,
254.
my lords. Here, the orders of the learned single judge, which was under challenge, was dated 13/6/2023.
Right. This is 24.
Yes, that's
This is
24.
later development.
No, what I want to, no, it's actually this, the matter which was under challenge before the division bench, the coordinate bench, and the matter which is now impugned before lordships came up on the same day. Two different orders were passed. So that's
Okay. 13/6/23.
13/6/23.
What do you say?
File wakalat for R3 also and take notice that some time we have granted so that I'll go through it and make some.
See, now what the senior counsel is saying is the date has now been changed to November 21, 28.
Yes, yeah.
That's the date of possession, 2008.
Yes.
That's one. And on the compensation,
This doesn't deal with the compensation,
it doesn't deal with it.
but my lords have produced documents to show that the immediate neighboring lands, which is part of the same survey number, is awarded with the compensation and amount is disbursed. That they can look into.
How much is that?
The 4 crore 76 lakh
You
rupees.
said so in your appeal,
Yes, my lords. These are the additional documents which has been furnished now.
How they filed an IAF along with the additional document that
Page 156 onwards.
then you must file your, where is your averment, Mr. Ravishankar?
Lordships.
We want to see that averment in your appeal. See if they have to.
I have stated it, minutes. Para 15, your lordships may kindly take minutes. She has produced documents before the single judge led by judge a letter dated 20 so and so. Respond 3, respond 2 by stating that de novo acquired the survey number 73 acres since the said land is already acquired in the year 2008. RTC reflected the name of state government. Subsequently, as per the orders of the special deputy commissioner, revenue records are reflecting the name of the applicant and also stated in the letter that with respect to adjacent land survey number 1, Arabinimangla village, in the same set of facts, one Muniyama Gangama, BC Narsimurthy were issued with fresh notification and they were awarded compensation as per the present market value. Those documents were part of the record notes before the learned single judge. Now, in respect of another adjoining property which was part of survey number 1 of Binamangala village, a memo was filed, my lords, by the KDB in another matter where they have said that this is the award of compensation which you have passed because similar matters were pending before another learned single judge. Lords, I just pass on those copies. This is a new development. They have themselves produced. May I just pass on this?
But you should give it to him also.
I'll.
So that.
This was filed by the KDB before the learned single judge.
Single judge.
Yes.
But the proceedings are still pending.
These proceedings, my lords, I'll have to ascertain whether these proceedings are pending.
And so we want to know.
These proceedings, I am instructed that they are closed, where they had filed these documents.
What happened?
Lords, so the award of compensation was done and it was accepted and closed, my lords.
In the manner.
In which we are seeking.
That's right.
Yes.
So we want to know.
I will file that copy of the order. I understand, my lords. Right.
You are challenging what has been awarded by the learned single judge?
Learned single, my lords, the awarding of compensation should have been left at the fiat of the acquiring authority as to what is the rate at which they will have to award the compensation. Single judge fixes the rate of compensation that in another matter that should not have been done. But now we are in a position to demonstrate after the learned single judges passed the order that in respect of immediate adjoining properties, which are my immediate neighbors, the KDB has passed.
But we want their affidavits on record.
Please.
You are appearing for whom?
R4 I'm appearing, I will take notice for R3 also, Malad.
Who appears for the 1 and 2?
State.
One is a state.
One is state, but who appears for the land acquisition officer?
I will take notice for
him.
Yes.
And 4 you appear for.
Already appearing.
Tehsildar. The
State
state will
government.
appear.
Government.
Lords, 1, 2 and 5 will be by the state.
The so and so the council appearing for respondent number 2, 3 and 4 state that he intends to file counter affidavit oblique objections to the writ appeal. Let the same be filed within 4 weeks. And rejoinder be filed within 2 weeks thereafter. List on. Mr. Vishankar, you want us this to take on record?
Lords, your lordships may return it back, my lords. I will file it because your lordships is permitting me to file a rejoinder. Probably
you
they
file
should
it
form a part of the rejoinder.
File it in the rejoinder.
I shall.
26-9.
Please, my lords.
Serial number 22, Shri Nagaraj Hegde.
Lord, I appeal for petitioner in this case, appellant. Lord, challenging the order passed by the learned single judge wherein, my lord, learned single judge has directed the respondent number 4 to consider the representation which is produced at annexure T for the purpose of fixing the boundaries and to enter the name of the respondent number 1. Page number 27. In the first volume, my lord, there is an order.
But the appellants were party before the learned single judge?
No, my lord, they are not parties. Lord, without making us as one of the parties, since, my lord, we have filed a suit and we have challenged the sale deed executed in favor of respondent number 1. The suit is pending for consideration. While pendency of the suit, without making us as one of the parties, Lord, he has filed the writ petition and got an order. Lord, the appellant has misled the court and got an order. My humble submission is, my lord, they contend, my lord, this scheduled property, which is 4 acre 18 guntas of KR Puram, was granted land to the vendors in the year 1968. Lord, what happened, Lord, after the order of grant, the original grantee himself has sold all the properties by even to an extent of 6 acres land has been sold by the original grantee. Lord, taking advantage of the order of grant after the death of original grantee, Lord, the LRs, legal representatives of the original grantee have got the name entered once again in respect of very same land. And at the first instance, 4 acre 18 guntas was sold to third parties. Thereafter, once again, the very same persons have sold 4 acre 18 guntas in favor of the respondent number 1. So there are total number of fraudulent transactions in respect of the land in question, my lord. And even the respondent number 1 has sold in turn 3 acres and odd to the third party after this purchase. Now he comes with an application to enter his name in respect of 4 acre 18 guntas. He himself has sold the properties after the purchase, even though there is no land is available. Only papers in the land is available. Though no land is available, he himself has sold the properties. Thereafter, he comes and state that 4 acre 18 guntas he has purchased and his name has to be entered and boundary has to be fixed. Entirely, my lord, the court has been misled by the respondent number 1 to obtain an order. Even, my lord, the suit was pending for consideration. Because the very sale deed itself is questioned by the appellants. I have produced all the documents.
Who have initiated the proceeding before the land tribunal or whichever is the authority, before the civil court?
Myself, my lord, appellants.
Have you challenged there?
The sale deed executed in favor of respondent number 1.
By whom?
By the LRs, legal representatives of the original grantee.
Original grantee.
Yes, my lord.
And you were the first purchaser from the original grantee?
No, my lord. I am the third purchaser.
Third purchaser.
In respect of very same land, original grantee has executed general power of attorney, registered general power of attorney in favor of 2 persons. That has been produced, my lord, document number 17 and 18.
Is your date of purchase?
68, my lord, not purchase. It It is my submission is, my lord, it was a granted land in the year 1957. Out of there are 30 acres of land available in survey number 26, my lord. Out of which 14.9 acres land was granted to my grandmother in the year 1948 by the state government. And thereafter, in addition to that, 4 acres and 2 acre 14 guntas have been granted to me. So totally 22 acres land has been granted to the appellants.
You are seeking your right through the original grantee?
Yes, ma'am. Yes, ma'am. The suits are pending. Several litigations are pending. By suppressing all material facts before this honorable court, he has got the order. And now, Lord, on 16th of last month, Lord, they have come up with all police help to conduct the survey by taking advantage of this order.
How did the R1 got the land?
Through the sale deed.
From whom?
From the legal representative of the original grantee. That is R.K. Muthukrishna.
I make a submission.
Okay.
According to the, my lord, respondent number 1.
You are also considering yourself original grantee?
Yes, my lord. It is a granted land to me and my grandmother earlier to grant of this original grant, my lord.
So in a way,
please,
you being the original grantee, you have sold the land to them?
No, I have not sold the land, my lord.
You have not?
It is still with our possession.
Who are the legal representative who has sold the land?
That is, my lord.
Are they connected to you?
No, my lord. Nowhere they are connected. Nowhere they are connected. Me.
But tell us one thing, that you were not party before the learned single judge, no?
Yes, my lord. That is what I have filed an application
You
for.
not filed a review before the learned single judge. And then say everything.
That can be done, my lord. If the Lord liberty.
That's the proper course also. If you are not a party, the law is well.
That is why I have filed an application to grant leave, my lord. Seeking leave also file.
Yes, what do you say?
My lord, survey number 26 consisted, my lord, more than 25 acres. There is no dispute, my lord. The appellant's vendor was also a grantee. The respondent number's vendor also is a grantee. So, my lord, both of us are
Vendor in your favor, the person who sold to you.
Yes, he's also a grantee. There is no dispute about
What
that.
about
fact.
him?
He also claims, my lord, his vendor is also a grantee.
No, not my vendor, my lord. I'm not a purchaser. It's a grantee.
He or
He's a grantee.
yes, ma, he is a grantee. His father is a grantee. Now, my lord, there are different grants. The extent of land is totally different. My lord, we filed an application in survey number 26, do PODI and durasi, that is identify the land which has been granted to my vendor and give me my land. That was the application which was filed, my lord, before the revenue authorities. Since the revenue authorities did not consider my application, I filed a writ petition saying that this is the grant which was granted to my vendor. I have purchased it in 1993. Therefore, please direct for them to consider. Now, your lordship may kindly see the order, my lord, which has been passed. Your lordship may kindly turn to page 29. What is the order which has been passed? Page 29, internal page 5 of the order.
Yes.
Paragraph 6.
Yes, read it.
Learned additional government advocate did not dispute the fact that respondent number 4 had addressed the letter dated so and so to the Assistant Director of Land Records to take suitable action to incorporate the name of the petitioner in the Karta register, taking into consideration the circulars issued by the government from time to time. Respondent number 3, however, failed to act on the said order, and therefore it is eminent that the respondent number 3 is directed to consider and pass suitable orders on the letter dated so and so issued by the respondent number 4, which shall be achieved within a period of 3 months. So, my lord, there is no positive direction, my lord, to change. The direction is, my lord, to consider the representation dated 8/7/2019 and pass orders. Now, subsequent to this order, since they did not consider, I had filed a contempt petition also. When the contempt petition was filed, when the matter was pending, now, my lord, they have come, done durasti, PODI, identified my land and given me a separate survey number. Now, my lord, if he is aggrieved by that action taken in accordance with law, since, my lord, my humble submission before your lordship is, that was just the honorable single judge directed to consider in accordance with law. There is no specific direction as such. Now, my lord, if he is aggrieved by the work done by the ADLR,
there is a appeal provision under section 49 under the Land Revenue Act. He has to file an appeal. Now let us say, my lord, let us leave this apart. Now, my lord, he claims he is the owner of survey number 26 and he had filed a writ petition before this honorable court to enter his name in the revenue records. That writ petition, my lord, was dismissed. Writ appeal was filed. Writ appeal was dismissed. He does not bring to the notice of this court about all these facts. My lord, this appellant herein, who says that he is the owner of survey number 26, my lord, had filed an application to include his name in survey number 26 in the RTC records. Since that was not done, my lord, writ petition was filed. The writ petition was dismissed. He filed a writ appeal before this court, where even I was a party. Writ appeal was dismissed. However, my lord, the division bench gave him a liberty, saying that since you already filed a suit, establish your right before the civil court. That was the order, my lord, which was passed. My lord, I have the copies of it, my lord.
What do you say this?
Lord, so far as that is concerned,
Petition.
no, so far as that is concerned, I will have to go to, no, I don't have.
You, that's.
Lord, my humble submission is, Lord, my humble submission is the very same land.
See, you must check up this.
Yes, my
This
lord,
is something very, say that this is relevant.
definitely, my lord.
If you have filed it, you have sought your inclusion of your names in whatever documents that has been rejected, the appeal rejected. Where do you stand is an issue insofar as this appeal is concerned.
I will go through this, my lord. I'll go through.
Just go through this, is important.
Yes, definitely.
And we hope, according to the learner council, this is not mentioned in the appeal. It's a relevant factor. And you must put it to your clients, why they have not, if at all. Getting the point?
Yes, ma'am.
Just look into this.
Please. My,
The-
my humble submission, my lord, only submission, my lord. Now, why the respondent number 1 is claiming 4 acre 18 guntas of land in survey number 26/1. From whom he has purchased in the year 2016. After the purchase, he himself has sold 3 acre 32 guntas out of 14 acre 18 guntas, 4 acre 18 guntas.
4 acres.
Yes, he himself has sold. The respondent number himself has sold the property through the registered sale deed. So available land according to him only about around 15 to 20 guntas. Now he claims 4 acre 18 guntas once again.
Lord, again, the
Basing
fact
on the
might be
sale
wrong.
Based
Other-
on the sale deed, he claims only 4
Tell us
acre 18
one
guntas.
thing, That documents which he has given
Yes, ma'am.
is with regard to 4 acres and so much gunta, which is the subject matter.
Yes, ma'am.
You have agitated it, but you did not succeed. Even the appeal has not succeeded. How will this appeal be maintained?
That is, so far as that is concerned, I will look
You
into.
must look into first. First, look into that.
My humble submission is, my lord, 4 acre 18 guntas itself is not available for Podi Duras, my lord.
You see page 38 of that compilation which has been given by him.
But even we have purchased, my lord, another 5 acres 30. That my learned friend is not, my lord, informing this court. Other than the 4 acres 18 in 26, survey number 26.
Paragraph 4. The dispute centers around the mutation entry in respect of land property number at measuring 4 acres situated as Baswanapura, village KR-pura, Hubli. The appellant petitioner claims to be the owner. This on the basis of the recognized deed. At the same time, it appears that very property became sold to be R. Chandra, respondent 5, in the revision proceeding, respondent number 4, on the basis of the registered stated mutation have been effected in the name of this. The posted order of the assistant which has been challenged. In the order of recognition.
Well, I'll go through this order, my lord.
You must go through.
2 days time.
And
5.1 there.
now you see 6.2, page 41.
Or that is not so, my lord. We have filed a suit for declaration. We have filed a suit for declaration declaring that the sale deed executed in favor of respondent number 1 by the vendors, his vendors is null and void. It's not binding on. That is what this.
No.
Maybe.
What the appellate court has said is you have filed a suit. That's right.
I'll go through it, my lord, make a submission on this, my lord. Finally,
just
Monday or
saying-
Tuesday, my lord.
Filed a suit Then I've got tried to submit that the suit is only for injunction. It's no answer to set not the mutation entry effective pursuant to a registered document. Committed no error in upholding. 6.1, it is noticed, so to original institute of petition in respect of any property is pending. Even the prayer is made to set aside the sale deed executed by respondent.
Lord, before that, Lord, I'll bring it to the notice of this honorable court. Kindly come to page number 268 for a moment, Lord. Well, volume number 2, Lord. Volume number 2, 268, Lord. This is the registered general power of attorney executed by the original grantee.
Page
In
number.
favor of on B.S. Sanawalla.
Page number.
Page number 268. Volume 2, my lord. This is the document executed by the original grantee, that is R.K. Muthu Krishna. Wherein, my lord, he has referred the grant order and he self, my lord. This is the site which was sold in pursuance of the general power of attorney executed by original grantee in favor of third person in respect of very same land, which is claiming 4 acre 18 guntas. So in this, my lord, he has executed the general power of attorney in favor of 2 persons in respect of 6 acres and odd, though the land was granted to an extent of 5 acres.
Correct.
He execute 2 registered general power of attorney, and after the execution, layout has been formed. The land has been converted into non-agricultural purpose and sold the properties. And thereafter the death, once again, the legal representatives have got their name entered in the revenue records, basing on the grant order.
See,
For
you have
entire-
see what is the effect of the earlier litigation.
They have no right to claim 4 acre 18 guntas. That is what my submission, my lord.
The learner counsel for the respondent number,
Respondent number 1, man.
respondent number 1 has relied upon memo, has filed objections to the IA, which is this IA.
My lord, delay of 400 days, my lord.
IA on condonation of delay.
Yes.
Which is taken on record. A copy thereof has been given to the counsel for the appellant, wherein he has referred to the earlier litigation initiated by the appellant herein to contend that the appeal is liable to be rejected. The learned counsel for the appellant seeks some time to file rejoinder to the IA. Okay?
Yes, ma'am.
Within 4 weeks, list on.
Lord, my humble submission would be, my lord, let there be a status quo to be maintained by the parties.
So you will file a response, please. There is an earlier litigation, we want to be very clear. Okay?
That time,
File your response to this, we want to know.
Lord, we are in possession of the property as on today, my lord.
Right, whatever
The
we
revenue
say,
documents itself is
say
produced
nothing.
before.
We say nothing.
Let,
The only thing we want a response to this.
Lord, my humble submission would be, my lord, let there be a status quo to be maintained by the parties, my lord.
No,
Till then, my lord.
no,
My humble
there is
submission.
there is a litigation earlier, 2 things, 2 with learned single judge and your own petition by the single judge and the appellate court.
That I will look into.
Next.
Much obliged.
2396. Serial number 23, Shri Nrsimhaswamy.
Responding.
Ayer.
Yes, Mr. Narayan Swamy.
I appear for the appellant in this case.
Yes, tell us.
There are 56 days of delay in filing the appeal, and I have sought
Okay,
for
what
stay.
is the case on merit?
Now, the case is, my lord, the subject matter of this thing is, the award was passed by the labor court on the dispute filed by this respondent 1 and 2. The dispute was allowed fully, and the reinstatement with 100% back wages was awarded by the labor court solely on the ground that charges are not proved. Thereafter, I filed a writ petition. Writ petition also has been dismissed by this learned single judge. Now, the fact remains, my lord, that it is a case where, my lord, these two respondents were working as pharmacists. Undisputed facts are they were working in pharmacists in the medical department of the BEML. It's a public sector undertaking. Their duty was to give the project. The duty was to project what exactly is the requirement of medicines, what is the quantity of medicines, etc. The allegation is that they made the inflated projection of these documents and these medicines, especially certain kinds of medicines which were in great need by the employees, because it was specifically meant for employees of BEML, like cholesterol control medicines or some similar medicines. They made a inflated projection. They did not give it to OPD. They utilized it for personal gain. And to cover up all these lacuna, they have deliberately destroyed certain records, like some registers were there. They have destroyed these records. Not only these two persons, there were about 6 to 7 persons who were involved, including a doctor who has also been dismissed from the services, and her writ petition is also pending before this honorable court, before the learned single judge. And an attender was there. He was also involved this particular. He was also dismissed from the services. His writ petition is also pending. Only in these two writ petitions, the learned single judge has allowed the writ, dismissed the writ petition, confirmed the award of it. This is the sum and substance of the matter. So matter requires detailed hearing. And one thing which we could not do is, before the labor court, of course, during the course of 33(2)(b, approval application was filed. We have examined the inquiry officer, concerned inquiry officer before the tribunal. Inquiry was held to be fair and proper. Thereafter, on technicality, the approval application was rejected. We filed a writ petition. The learned single judge allowed the writ petition, set aside the order of the tribunal, approval was granted. Thereafter, when this similar issue was taken up before the labor court, we could not examine the inquiry officer because he refused to come. By that time, he was also left the services. We could not secure him. We have not examined. Because we have not examined the inquiry officer, inquiry was set aside. On merits, to prove the charges, we have examined 3 witnesses, including the main complainant and the investigating officer.
But you produce the evidence witnesses.
Yes, my lord. I have produced the entire set of records from the industrial tribunal to labor court, whatever that was recorded. I requested, but that was not taken into consideration. The labor court passed an order, only one paragraph, saying that since the burden of proof mainly lies on the management to prove that inquiry is properly conducted or not, since they have not examined the inquiry officer, inquiry set aside.
No, inquiry set aside, but they, in any case, the liberty must be given to you to.
We have examined 3 witnesses.
So it's only thereafter.
Yes.
So that is now is a history.
No, I have questioned the order passed on the preliminary issue also.
Why should you do it now? You have been given. Tell us otherwise, how would you justify inquiry? Who will prove the inquiry? The inquiry officer.
We have to prove that, but
the inquiry officer.
Since it was held to be fair and proper before the tribunal on the same set of facts.
No, right, you're right. But the only thing is, unless you rely upon that order to say that it has been proved, hence you should not prove it, that is not your case.
No, that is not my case.
So
I have only said
you are asked to produce, to prove the fair and proper, the inquiry, you were to produce the inquiry officer, which you could not. But in any case, the liberty was granted to produce the evidence to prove the charges.
Of course, since the inquiry was set aside, I have to prove the charges of right. I have examined 3 witnesses and.
Now, what is the conclusion on?
The conclusion of the labor court, my lord, they totally refused to take the evidence of all the 3 witnesses and gives a finding that this document cannot be relied upon, that document cannot be relied upon. This document is not, in support of the charges. Like this finding is given by the labor court. Totally, my lord, and ultimately the charges are held to be not proved. Hence, they are entitled for full record.
What happened in the connected matters?
The one is an officer, separate set of facts. Her writ petition is still pending before the learned single judge. And the other one is a worker similar to this. And we have succeeded in the labor court that writ petition is still pending. They have filed the writ petition. We have succeeded in the labor court. Those writ petitions are still.
Unlike him, you succeeded there, unlike in this case.
Please, my lord, please, my lord. That is the position.
That's also under challenge.
Yes, they have questioned it. Both approval order and
Ready to argue?
uh,
Ready to
If-
argue, is your record, labor court?
no,
record?
that is not come, I think. Only first time this is coming up for admission.
We'll call for the record.
And now that I am told that they have initiated prosecution. Till then, if they are not
No, no.
pressing that,
No, sorry, we have not initiated.
initiate prosecution, we have been issued with the show cause notice by the labor.
We will not
Department.
initiate.
Let the record of the labor court be requisitioned before the next date of hearing. We have been informed by Mr. Narayan Swamy,
Narasimha Swamy.
Narasimha Swamy, that the respondents herein have initiated execution proceedings.
Prosecution, yes.
Prosecution says, say prosecution proceeding, the learner counsel for the respondents 1 and 2 states that during the pendency of the appeal, those said proceedings shall not be pressed.
Yes.
Okay, the statement is taken on record, re-notify on.
Please,
26-9,
please.
number 24.
I appear for the appellant.
Yes, ma'am.
Now, in this matter, the respondent number 1 and 2 had retired from service on 8th August 2011 and 26th April 2011. And their pension was sanctioned at 2091 and 2065. Now, the respondent had approached the authorities seeking for a revision of pension on the basis of R.C. Gupta's case. And erroneously, the appellants have revised the pension of the respondent number 1 to 11,758 and arrears of 8,67,554 was paid. And to respondent number 2, the pension was revised at 6,610 and he was paid an arrears of 4,23,000. Now, after that, as per the R.C. Gupta's case, it was found that the person had to opt under 26(6) of the scheme. Now, these persons had not opted for under that scheme. Now, in the present case, only on the ceiling limit, they had contributed to the pension fund. Therefore, later, as per the law laid down by the R.C. Gupta's case, the contribution was not on the higher salary, hence a letter dated 8 July 2019 was issued to the respondent number 1 and 2, to the respondent number 1, stopping his pension as to avoid erroneous payments. Now, the respondent thereafter have filed the petition 9460 of 2020, seeking interest on the arrears of the pension paid since the date of retirement till the and for stay of annexure B. Now, the Honorable Court granted an interim stay of annexure A, and his pension was restored to the statutory limit. Now, at that time, the issue of grant of pension on higher pension was pending before the Supreme Court in SLP 8658 of 2019. Now, in that matter, the order was passed saying that firstly, an order was passed saying that no contempt petition will be issued, saying that if the in respect of the implementation of the R.C. Gupta's case. Now, in spite of that, as per the order dated 25/2/2021,
Tell us,
at
ma'am,
page
ultimately, what is the order
the order passed by the honorable single judge is that this petition is squarely covered under the provisions of the Supreme Court order. But at para 9 of the order, that is at page 27, it says that learned counsel for the petitioner at this stage submits that interim order granted by this court on 4/9/2020 to be continued till consideration of the representation by the respondent authority. Now-
What is the direction?
The direction is that I have produced that
Where is that? Where is the 4/9 order?
4/9 order is at page 190. The second page, page 191. Now, in this case, that is pertaining to a different case. Now, the court says that this order has to be continued in the present petition. And that is the part which I am challenging before this court. I may be permitted to read.
Yes. Now, what is the grievance in this? What they have said is, the learned judge has a consequent arbitrary decision taken to restore by the Foreign Commissioner to restore the retrospective and may cause irreparable damage. So there, the old pension must not be restored. Must not be retrospectively. You will not from a back date restore the old pension.
No, but that is in a different case. In this
Right,
case,
but only thing is, let's forget it, that there was a case, he has followed the earlier judgment. Can the judge on its own, when he has directed you to consider the representation based on the judgment of the Sunil Kumar, pass an order?
yes.
Till such time you pass an order, what is the order you will be passing, restoring old pension from a back date?
No, it is already restored.
You have already restored?
Yes.
Very well. If it is restored, it's restored. If it is not restored, then you will not do it.
Yes, but
When did you restore? After the learner single judge order or before that?
no, before that.
Before that?
Before.
Yes.
Then Mr. Abhinav, what is the relevance?
I'll just explain. My lord, contribution, my lord, two options are there under the PFF. Either I pay on the ceiling salary, which they fix at, my lord, initially 5,000, then it became 6,500, and it became 12,500. So I make my PF contribution on this ceiling salary, or my lord, I'm given an option to make contribution on the actual salary, that is exceeding this salary. But undisputably, my lord, I have made contribution on the actual salary, more than the ceiling salary. There is no dispute about that. My lord, but the pension is fixed, taking the ceiling salary into account. In R.C. Gupta's case, my lord, what the Supreme Court said is, if contribution is made as per actual salary, it is only a book entry that you have to make. If there is any interest or arrears you want to collect it and work out what is the actual pension that is to be paid on the contribution made on the actual salary. So that is R.C. Gupta's case. But in pursuance of that, they raised demands saying that this is the amount you have to pay. My lord, we paid those difference amounts to them. They refixed the pension and started paying the pension.
Pension on the basis of the.
Yes, actual salary. Earlier, my lord, they were paying me pension on the ceiling salary, though I had made contribution on the actual salary. Actual salary, my lord, is about higher. So therefore, my lord, R.C. Gupta's case, Supreme Court said it is only a book entry because contribution is in your pocket. If there is any difference in interest or anything, you please collect that and then refix the pension. Well, they issued demand notices, PF authorities issued demand notices, collected the difference amount, collected interest, and then refixed the pension based on actual salary. Well, they started paying that pension. Abruptly, my lord, without notice, one fine day, my lord, they stopped it and reverted me back to the earlier pension that is on the ceiling salary. He came before this court and said, this is not done, not even a notice is given. They issued demand notices, we complied with it, it is refixed by an order passed by them. Without issuing any notice, they can't revert me back to the old pension. So in that context, my lord, our interest was protected, saying, no, you have collected amounts from them, continue with the pension that is refixed till the matter is decided. Now, what the learned single judge has done is, now there is Sunil Kumar's case, and in Sunil Kumar's case, my lord, R.C. Gupta's case is upheld. So what the learned single judge did, my lord, at para 8 said, you please give representations and your calculations. Let the PF authorities consider this. Till they consider it, don't make them run back to the court again. Let whatever state of affairs is continuing, let it continue.
So what are you getting? Higher pension?
Higher pension I am getting.
Based on the actual salary?
Based on the actual salary. Then, my lord, I make a representation to them. What has happened to that representation, my lord, in pursuance of this judgment, my lord, I made a representation. What has happened to that representation, my lord, I'll just take instructions. Because in pursuance of the order of the learned single judge.
Tell us one thing, ma'am, have you decided the representation? Then that's the end of it.
I'll just take instructions, my lord. Representations were given as a matter of fact. What has happened, my lord, I need to inquire. My lord, delay can be condoned, my lord. There's a marginal delay that can be.
No, we can dispose of the
Yes,
appeal
dispose
itself. If a representation is over, then, but the only her grievance is pending what we have understood, pending decision or representation, she should be allowed to go back to the ceiling, the pension as per ceiling.
Yes.
No, we have already gone back to that ceiling in April 2019
What is- no,
itself.
What is the position today?
Today also we are paying them only the old pension. We are not paying them the higher pension.
Then you should have pointed out to the learned single judge, look here, that we are now paying pension on the old ceiling or old that ceiling salary, not on the actual salary. You should have said.
That is not the position, my lord, because we were all protected by an interim order, my lord. They were paying us as per actual salary.
So your instruction is you are getting actual salary.
Actual salary, my lord, till the
As
disposal
per
of.
my this, it is.
Okay, forget this, ma'am. But have you decided the representation?
I will just verify.
That's all you have to verify. If representation is there, you will go in accordance with the representation.
Either, my lord, they will accept me, my lord, in which case I am, my lord, protected. If they go against me, my lord, I get another cause of action, my lord.
You have a grievance there.
Yes, my lord, I'll have a grievance. I'll come back.
Come back after lunch, take your instructions.
No, your lordship may kindly have it on Monday. I have some personal inconvenience in that.
That the request of the counsel for the appellant to take instruction. Re-notify. Even you have no idea.
My lord, what has happened, my lord, is I called my client yesterday, my lord. They say, my lord, the intimation which the PF authority says, please check online. Online, my lord, it is because we were asked to upload all these things online, my lord, so that it is digitalized. Online, my lord, nothing. So therefore, if my learned friend can help us, my lord, in this to say what has
If
happened.
representation decided.
Yes, my lord, that is the end of the matter.
You
One
will
way or
lock
the
it
other.
up, one way or the other.
Yes, my lord.
Say give 23rd, 22nd,
22-8.
Yes, grateful, my lord.
Yes.
Fine, government.
My lord, week's time may be granted in this, my lord.
Just showed it. There is no notice on this.
No notice. This is in respect of 5% land bank.
Just say that at the request of counsel for the appellant, we notify all. Long day.
Thirtieth 9. Number 26, Srimati Lata.
I appear for appellant in this case, my lord. Please, my lord.
Yes.
My lords, being aggrieved by the dismissal of the writ petition filed by the appellant herein, the appellant has preferred this writ appeal, my lords. There is a short delay of 4 days in filing this writ appeal, my lords. But the facts of the case are,
What is the case on merit?
my lords, certain allegations were made against the appellant herein who was working as conductor cum driver. Inquiry was conducted. Inquiry officer found that the allegations are not proved. Thereafter, the disciplinary authority has taken dissenting note. While dissenting note is in transit, dismissal order was passed, my lords.
Yes.
Without hearing me, the order of dismissal was passed, my lords. Challenging the same, I have preferred.
Why do you say without hearing you?
The dissenting note was drawn on 18/6/2016, but it was
But you refused.
no, my lords. It was posted on 19/7/2016, my lords.
But that's the finding.
Yes, my lords. Dismissal order was passed and served on me before dissenting note reaches me, my lords.
That's right, but he will, when he is giving a dissenting note, he will ask you to represent against the dissenting note.
Please, my
You
lords.
don't accept the dissenting note, you refuse it. What will the authority do? They'll
Lord,
pass an order.
Dissenting, my lord, the dismissal order was passed on 27/7/2016, my lords. I
Okay.
refuse to accept the dissenting note on 30/7/2016, my lords.
Oh, afterwards.
Afterwards, my lords.
But how can he pass an order when there is a dissenting? How can he pass an order of dismissal?
My lords, kindly peruse. I request your lordship to please have a look on page number 139, my lords. That is the order of dismissal. Whereas the
Now,
dissenting note was in process.
What is your
My lord,
case?
it was sent to him, my lord, on the dissenting note, my lord, was drawn on 18/6/2016, my lord,
18/6?
2016.
And
he was called upon to submit his reply, my lord. It was the dissenting note, my lord, was sent to him through registered post. In fact, my lord, the learned single judge, the records were before the learned single judge, my lord. He was given, my lord, hearing at length, and even the thing, my lord, the records are required, my lord.
No, we want to know this. What is the date of dismissal?
My lord, date of dismissal is 27/7/2016, my lord.
What is the date of dissenting note?
18/6/2016. 16, my lord.
Oh, 16.
My lord, what the learned single judge,
Did he refuse the dissenting note?
my lord, he says it is on 37, my lord. But the learned single judge, my lord, what was pleased to observe, my lord, is that either way, my lord, you are not aggrieved because you refused. Even if your lordship, because the plea that is, my lord, taken is only
Yes.
my lord, ultimately, my lord, he refused.
But tell us one thing, this is surprising for us. The dismissal order is before the dissenting note issued. How
No,
can that
no,
be?
no, 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 my lord. Dissenting notice 18/6/2016.
So it was sent on that date?
My lord, it was sent on that day, and he did not, because it came as, my lord, his party is not available. If your lordship could see the, my lord, I'll just point out, my lord,
We want to know when was the dissenting note sent?
My lords, it is on page number 137, my lords. 137, my lords. It was under the transit when the dismissal order was passed, my lords.
But why should we hear you on this when you refused it?
My lords, I have not refused it, my lords. This dismissal order was passed prior to receiving dissenting note, my lords. I was under the impression that the dismissal order is again sent to my address, which was already taken by me, Buddha, my lords.
So this is only now in retrospect you are saying so. But otherwise you refused.
even in, my lord, it was noticed, my lord, that he could
uh,
have filed an
dismissal
appeal
order
also,
was-
my lord. He did not even file an appeal pointing out this. And since, my lord, what the
We want to know when was the dissenting note sent?
my lord,
My lords, it is in page number 137, my lords.
Yeah, 137. What is the date?
19/7/2016, it
My
was
lord-
posted, my lords.
my lord, on
No, but that's not the.
no, it was sent, my lord.
See the page 138.
Please, my lords.
Yes.
These are all dates are of 2016.
Yes, my lords.
My lord, 22/7/2016.
And when was the date of dismissal?
27/7/2016, my lords. 27/7/2016. Very next page, my lords.
My lord, what the learned single judge has noted, my lord, that intimation was, my lord, intimation was given by the post office, my lord, or to collect the letter, my lord, on 22/7. 22/7, it goes to his house, my lord, and an intimation is sent by the postmaster, my lord, to collect this. He doesn't collect. On 23/7, he doesn't collect. 25/7, he doesn't collect. 26/7, he doesn't collect, my lord. All this postal notice noted.
When did you came to know that he has refused?
Yes, my lord.
When did you come to know?
My lord, the disciplinary authority, my lord, has noted that, my lord, it was sent to him and he has not replied. That's how, my lord.
Okay, let's see that finding.
Well, it's reference number 9 in the dismissal
Well,
order at annexure.
My lord, in Kannada, it is 141, my lord. In English, my lord, English, my lord, I'll just point.
Where do you narrate that he has refused? Till such time you come to know that he has.
Page 148, my lord. 148, however, the disciplinary authority has rejected the decision findings of the inquiry officer. The disciplinary authority has submitted his opinion, wide reference 8. Said opinion was sent through registered post as the accused is in long period of absence. Has said employee has not submitted his explanation.
When did you send
My
it?
lord, what we have said, I think the translation may not be, my lord. I'll just translate, my lord, from Kannada, my lord. The disciplinary authority, wide reference number 8, has disagreed with the findings of the inquiry officer. The said findings was sent by registered post since the delinquent is in a long unauthorized, long absence, and he has not submitted his reply. That's all, my lord. That's stated in the dismissal order.
When did you send this?
My lord, this was sent
On.
(27/7), my lord.
No. My lord, 22/7, there is
It cannot be 27/7. It was sent before that.
yes, my lord, because there is a postal shara, my lord.
22/7/16, 23/7/16, 25/7/16.
My lord, it says, my lord, 19/7, my lord, 2016, my lord, it was sent. 19/7, my lord. The post office seal in the first page, my lord. If your lordship could see page 136, my
We
lord.
want to know, how did he come to know he has refused?
My lord.
Then only you will act.
Yes,
Then
that's
only disciplinary authority will act. When did you know? He's trying to be clever, that's all. For how long he was unauthorized absence?
my lord, this present case was not absence case, my lord.
Present case is,
The present case is again, non-issue.
what are the charges?
Name, my lords.
What were the charges against you?
Lords, the appellant, while he was in the course of employment, did not come to Bangalore and stayed at Koppal and handed over electronic telling machine and the money to one Devaramani and who has
Okay,
deposited the money, my lords.
So you say you were not well, you got down.
That was the allegation, my lords, which was not
No,
proved.
that's your case.
My lord, in fact, my lord, he was required to
What is your evidence? What is your basis for him to say that he was unwell? He got down and went to the hospital, OPD, and your case is he did not go.
yes, my lord. In fact, his own evidence, my lord.
We'll ask him, what is your basis to say that you were unwell and you went to the hospital?
Lords, he has submitted doctor certificates in the
Where is that?
inquiry
Show
officer.
that.
It's the inquiry officer in his report at page number 127, my lords. He has narrated in 127, my lords.
Yes.
May I read out, my lords? No records found to prove justify that Devaramani boarded the bus near Nelamangala toll gate at the time of Sharanappa Angadi. At the time Sharanappa Angadi suddenly vomited. It spreaded in the bus. Situation may lead to chaos, which no other way out. Sharanappa Angadi handed over his ATM machine and transport income to Devaramani, who was doing duty in the same depot, told him to deposit the cash, handed over the items in the depot, and also got down from the bus, went to nearby government hospital at Eganadli, where he got treated and recovered. That Devaramani remitted transport income to the depot. That is the explanation by the delinquent. There are no evidence to show that the delinquent got down in Koppal and went away. Likewise, records not found to prove that he got down from the vehicle at Koppala itself. Vehicle was driven / run from Koppala to Bangalore. In the middle number of passengers would have boarded the bus, paid bus fare, obtained tickets, got down and went away. No mention in this regard found in any of the records of the management.
Where is your case? You went to the hospital.
Let's have submitted the records to the inquiry officers. I may be permitted to produce the records.
We don't know, but that's the case you have set up. It has been disbelieved.
1 second, my lord. Sorry, my lord.
It has been disbelieved.
My lords, even otherwise, I must be given an opportunity to say, my lords. That was not given, my lords.
That we are not convinced.
My lords.
In retrospect, now you are saying, look here.
No, my lords. My lords, the dismissal order was passed on 27/7/2016, my lords.
Okay.
Dissenting note was sent on 19/7/2016, my lords, giving 2 days time, my lords. Dissenting note, if at all, if the disciplinary come to conclusion that I have refused, they should have passed the order after the refusal, my lords, not before that.
But you were given 3 days. After 3 days from 19, they passed the order. You were in that show cause notice. You were given 3 days.
Yes, my lords. It was served, it was sent to me on 19th, my lords. It was quoted on 19th.
So 19 plus 3, 22.
22, my lords.
When did they pass the order?
27, my lords.
So they waited for another 5 days.
No, my lords. Theory of communication cannot be accepted, my lords.
But tell us one thing, how will that help you when you refused it?
I have refused on 30th, my lords, because
doesn't make any difference.
My lords, the dismissal order was passed and served on me on 27 itself, my lords.
That's the reason we are saying now.
No,
you will show you were unwell and you went to the hospital.
Yes, my lord.
Did you file any medical documents before the
Yes, my
inquiry
lord.
officer?
Yes, my lords. They have
Where
got
are
marked
those?
as exhibits, my lords.
Where are those?
They are in the inquiry file, my lords. Kindly have it tomorrow, my lords, or Monday, my lords. I'll produce, my lords. A fair chance may be given, my lords. My request, my lords.
Appellant to file the documents which he had submitted before the inquiry officer. Re-notify on.
12/9.
Next.
Grateful, my lords.
My lords, the next matter, my lords, may I seek my lord's indulgence. The statement we have served the copy of on the other side, my lords. May I request may be taken up on Monday or Tuesday, my lords. Postland some inconvenience for me.
When is the matter now before the court?
Please
Special
next
court?
matter. My lords, this is a matter pertaining to the land grabbing, my lords.
No, when is the matter?
Date.
13th
This was the date.
next month, 13th of September.
13 September.
Next week, any day.
Very well. You want to file any response to that? Who is appearing? You appearing?
May permitted to my lord file counter to rejoin it to
The objections, you have filed it on record.
Please, my lords, it's filed by way of a soft copy.
Do
my
one
lords.
thing, man. File it in the
We
register.
will do.
We will appreciate if you can file it through e-filing also.
E-filing is done yesterday only, my lords,
We
but
have done it.
we have done e-filing, hard copy. I'll just have.
Just file it in the register.
We will do the same.
Then the counsel appearing for the respondent states that the objections have been filed through e-filing. Full stop. Additionally, she shall file the physical copy of the
Please.
objections in the registry during the course of the day.
Please, great.
Full stop. The learner counsel for the petitioner seeks and is allowed how much time?
week's
2
time. A week's time, 1
A
week.
week's time to file rejoinder to the objections filed by the state. Full stop. Re-notify on, just give it in first week of September.
39.
Please.
One under intelligence, my lords. Serial number 35, the matter pertaining to grant of MACP of the employees of IT minutes. Learned ASG has been briefed in the matter. Today he has got some inconvenience. Could it be taken on 20th matter by some? There is a direction also, request by the Supreme Court also to visit.
Right.
At
When
20th,
was the, Mr. Kumar, when was the direction given?
matters was in the 2023 one, that's
The request of Mr. Kumar appearing for the petitioner, comma, for adjournment, re-notify on. When do you want?
20th this month.
20?
August, it's
No, we will have it some other day, 22nd or 23rd.
20th.
Okay, just give that date.
Serial number 27, Malay, taken up next week, Malay. Today I have done. Serial number 27.
27 is old, no?
No, that is 29, sir.
No, no, this 27. Acha, you have a difficulty.
Yes.
When do you want?
Next week.
Where is he?
I'm here.
Which way? But he will appeal.
Well, that was 26, my lord.
Acha, that was, this is a new matter.
Yes.
Yes.
What is the difficulty?
Some inconvenience.
Huh?
Some personal inconvenience.
Personal?
Inconvenience.
Sure?
Yes.
We will have it then. 27.
Your lordship-
Whatever is the date, man, just give it.
With the lordship kindly, my lord. One matter, my lord, your lordship.
5-9.
Yes.
But the matter was reserved on Monday. That's my lord.
Madam, same day.
In respect of my lord, age 44 years, my lord, 35 in respect of deputy registrar, my lord, in the university matter, where we have to, my lord, supply the list of citations.
Relaxation.
Please, my list of citations.
Take that.
List of citations, my lord.
Just take that. Okay, thank you.
ಅದೇ ಗೊತ್ತಾಯ್ತು ಅವ್ರಿಗೆ ಏನು ಅಂತ ಕೊಡಬೇಕು ಅಂತ ನಾಳೆ ರಜಾ ಅಂತ
Lots and leave. Seal number 30, please, my lords. This, my lords, is questioning an interim order passed by the Honorable Tribunal refusing interim order, my lords. Against that, my lords, I had come before my lords. Now, the original application, my lords, itself is disposed of, my lords. Therefore, the seal number 30, please, my lords, 3087. The matter may be disposed of, my lords, as having nothing survives in the present writ petition. OA is disposed of, my lords. This is the instant writ petition is against an interim order, please.
Counsel for the subjects and the way itself has been disposed of.
Please.
This appeal, this petition has become infectious.
Please.
And then we disposed of.
Please.
Grateful.
IA 1/22.
Grateful.
Serial number 30, this is 30. For pronouncement, 37, Vinod Kumar.
Mutation order passed by resolution number 2 bearing 01 CR 10/6/2022 and consequent confirmation order bearing number 5257 SSP 2022 Bangalore 56/2022 passed with the response number 2 stand quashed. Consequently, the response are directed to the liberty forthwith. However, the issue is directed to communicate this order to respond number 2 and 4 as well as the jail authorities to release the integrating forthwith in case it is not required in any other cases.
Please.
Serial number 28, Shri Basuraj. 28.
Yes.
My lordship, the respondent officer was working in Bangalore in DOT, that telecom. He has been transferred to Jammu, proper Jammu, that is a peace station and also family station. While working in Bangalore, he retained the quarter allotted to him. On transfer to Jammu, Bangalore.
And was he allotted a quarter there in Jammu?
No.
He was getting HRA
Yes.
for 8 months.
For 8 months, he drawn. No objection for us, from our side. After that, after 8 months, he draw the HRA that was been subsequently recovered on audit objection. That is the issue, my lordship.
Yes.
Respondent retired on 30th of April 2020. Then after 2 months, supposed to retire. In respect of this judgment of the Honorable High Court of Delhi on 26th of September 2020. Same aspect has already been covered.
My lordship, that is not a binding for this court. Moreover, Ministry of Expenditure has asked them to last time also supplied my lordship.
What did he say?
Last time, that Delhi High Court judgment is not binding, it is not a precedent. Somehow they have given, but Ministry of Law, that is the Ministry of Expenditure now asked them to challenge the orders. Inadvertently, that has been implemented.
She was said there. The transport allowance.
Please, but if I am permitted to read paragraph number 18, what has been observed?
Yeah, right from that High Court. Yeah,
Please, Let I taking attention in this matter also, she was a group A official. This matter.
Oh, he is retired.
She is retired. And what has been observed here? Paragraph number 18, if I may be permitted to read out. Though on that day, December 23, 2014, the petitioner had not retired, but in terms of clause 2, she was due to retire within 1 year of the order December 23, 2014. On this ground itself, the respondent could not have made any recovery from the gratuity.
My lordship.
And subsequently, if I may be permitted to read subsequent paragraphs. The plea advanced by the learned counsel for the respondent that the insurance action has been taken by the respondent with regard to similarly placed officers, and as such, any order in favor of the petitioner shall open a Pandora's box, as those officers shall approach this court seeking similar benefit. And paragraph number 20, we say nothing on the submission made by the learned counsel for the respondent, in as much as the petitioner having approached the tribunal which had dismissed the OA, and now she has now approached this court against the order of the tribunal, which we find is erroneous, as the judgment in Honorable High Court of Punjab and Haryana and the Russian declaration on which the tribunal had relied upon has no applicability to the facts of this case, and the petitioner is right in relying upon judgment in Rafiq Masih and others, clause 2 squarely attached to the facts of this case. The actually
Has been taken into.
No, as far as I'm concerned, I have verified what is simply what they are not confident.
My lordship, that Rafiq Masha case is only the applicable for the low paid employees, group C and D, not for the officers. He was a senior DDG drawing the more than 2 lakh rupees.
Yes, but tell us, Mr. Baswara, he has retired, huh?
Yes, my lordship.
You say this. I'm now in Karnataka, not in Delhi. Okay. But I can't separate myself from me unless and until I argue that this judgment is erroneous. We will consider that. Is it your case?
Yes.
That this judgment is erroneous? We'll possibly look into it.
Yes, my lordship.
What do you say now? He has retired, and then the Masih also consider that particular aspect also. The challenge, we will dismiss it. Petition, this petition has been filed by the petition in the order of challenging the order of the central administration by whereby the OA filed by the response has been allowed by the stating in paragraph 16 and 17 as a law. So, Mr. Baswara, actually, the counsel for the appellant petitioner has made several submissions in challenge to the order of the tribunal. In one aspect which has been pointed out by the for the respondent is that after the judgment of the tribunal, the respondent has retired on attaining the age of superannuation on
23.
and also the fact that the council has brought our attention to an order passed by the Delhi High Court. Wherein one of us, we cannot give this. In the parking, the High Court has also considering the aspect that the petitioner therein just take his details. Petitioner therein the Delhi High Court considering the aspect that the petitioner therein had retired within 1 year of the order of 23rd December 2014. What is the order here?
16/2/2023.
Had not interfered with the action of the respondent therein to make recovery from the, no, you can say, had set aside the order of the respondent making recovery from the gratuity of the petitioner. Similar is the case herein, we have been informed that the order of the impugned order which has been challenged by the respondent before the tribunal is dated 16/2/23. Beyond 1 year. Did not beyond 1 year.
No, 16/2/2023, include order was signed, and 30th of April 2023, 2 months.
Acha, and the respondent had retired on
30th of April
23. That is 2 years, 2 years pursuant to the impugned order.
2.5 months.
2.5 months from the date of the impugned order, that is 16/2/2023. Make us not to entertain the present petition filed by the petitioner challenging the order of the tribunal. So accordingly, the petition is dismissed.
After having showed for almost 25 years, the next instance, the amount has been given. The gratuity amount and even from salary, the amount was given.
Now the tribunal's order is there, I think they will act.
But Jammu is a police station, that stands as it is, my lordship.
We say nothing on that,
Achha, my
There is
lordship.
only a recovery that has been set aside. Rest everything that will.
Because there should not be a precedent, my lordship, that's why.
Say nothing on that, on a given facts.
Yes, my lordship.
Yes. Yes. Who appears for the state?
So I'm prepared for the state in this case, Lord. I pray for 1 week time to come out there. Right now only I have issued that file from that office.
We will have that, but we have to also read the file. We have not.
The date may be fixed next week.
You just say this.
Only request was because the objection itself is rejected while considering discharge. Though I am a person who holding the property by sale deed, the learned judge has rejected my objections itself. Till there such time, let there be an interim order. My lord. They are proceeding to frame charges.
We have to go through this. Petition has been extended. This petition has been listed through a supplementary list, supplementary cause list. As the date was given as 14/8/2024 on a memo. On a memo,
Filed earlier.
6/8/2024. We're gonna re-notify this petition on 28.
28.
Trial court is on 29th, my lord. 28th is all. Much of it. I filed the translated and versions. All the translated versions. Yes, madam. It shows the sale deed is there, madam. And they have carried out revenue survey recently and changed the very nature of this land, and two people they have already recognized. 14 in the same survey number, they have recognized two other persons and regularized them. My application for regularization is pending.
31, serial number 31, Mukkanappa.
For respond, my lord. So from the department, from the department.
Yes.
Yes. From the instructions I received, my lord, there is no such prayer has been given to the surveyors. So cat order is.
Now you tell us. Where do you stand?
I understand.
He said,
Aye.
right on. 1600 is pre-revised, upgraded is 1640. They cannot be two fixation from the same date. 1640 and at a higher scale of. And that's what the tribunal wants. But what is the intent of this commission report is, now you will be given revised of 1640 on 1196, which they have given it to you. Your case is, you fix my pay in 1640 first and
Then,
revise. Want to pursue?
No, I leave it to lordship.
This petition has been challenged by the petitioner. Challenging the author of it. Sorry, Bangalore bench. Dated 21/6/22. Thereby the tribunal has dismissed the original application filed by the petitioner by stating in paragraph paragraphs 16 onwards, as under the counsel for the petitioner reiterate the submissions made by the submissions advanced on behalf of the petitioner before the Central Administrative Tribunal. So on the last day of hearing, we had passed the following order. The learned counsel for the respondents would submit as per his instructions. As per his instructions, there are no cases where the prayer has sought by the petitioner before the tribunal was granted in favor of certain persons on the post of surveyor. That way, so the conclusion drawn by the tribunal in the paragraph which we have reproduced above cannot be faulted. So this we say so, this we say because in terms of the recommendations of the CPC, petitioners have been granted the upgraded scale of the scale of the petitioners has been upgraded from 1600-2660 to 1640-2900. The revised scale on 1/1/1996 as necessarily to be that of rupees 1640, 2,900. And 900 and the fixation of pay shall be in the said scale only and not in the manner sought by the petitioner before the tribunal. We do not see any merit in the petition.
I appeal for the respondent.
Petitioner, my lord. My lord, the petitioner was working in the postal accounts department, my lord, as a senior accountant. My lord, after getting third MACP benefit, she sought, the stepping up of pay in pursuance of the order passed by the principal bench, my lord. Accordingly, her pay was stepped up in 2014. Yes, my lord. On that issue, yes. MACP, my lord. She was. No, my lord, because there was some direct recruitment as accountants, and another batch was through LDC, UDC, and then became an accountant. They got 3 promotions. So they were not given the MACP benefit. And whereas these persons, my lord, they got a higher pay. On that issue, my lord, there's those direct recruits as accountants. Because page 50 is the order of the principal bench, my lord. Yes, madam.
Those conditions need to be fulfilled.
No.
If you are similarly placed.
That is not an issue, my lord. The fact I want to bring to your lordship's notice is that stepping up of pay done in 2014, she retired in 2019. The time of retirement, she was asked to repay about 3,34,000 rupees, my lord. That, yes, that order was challenged, my lord, before the CAT. CAT passed the order, my lord. Finally, she page 66, annexure A11, my lord. Now retired. 2019 itself, she retired. The performance, for criminal benefits, it was recorded, my lord. Yes, currently she pays 79, my lord, first order of the tribunal. No, that is group B. No, but that question doesn't arise because she retired, my lord. I produced the Afiq Masaya case. 79, my lord, page. This tribunal remitted the matter to the authorities for fresh consideration. However, an exception was done, my lord, at page, the para 7. But in the case of retired persons, we will make an exemption that they need not be disturbed again if they have gained anything, let that gain stay with them. In accordance with the principles enunciated by the Honorable Apex Court in the Whitewashers case, OAS disposed as no costs. My lord, this order has become final. Respondents will not challenge this order. No, I'm coming to that, my lord. Subsequently, my lord, I intimated regarding my date of retirement to the authorities. They passed a fresh order, my lord, as per annexure, at page 90, annexure A13. No, my lord, this was order I questioned again. My lord, the tribunal. Yes, my lord. Against me also, and against the order of the CAT. CAT said regarding retired persons, an exception is made that you don't disturb them. Now say, my lord, the order is at, my lord, page 17, annexure A. I think they have dismissed the OA. Page 35. Accordingly, all the 3 original applicants, namely so and so, involving identical question of laws having a similar facts, be devoid of any merit, are dismissed. My submission is that, my lord, second order is without authority of law for the reason first order has become final. That was not challenged by the department.
But one thing is there, Mr. Ola, let's be very clear that 25, page 25 of the observation.
Yes, my lord.
25, that paragraph.
Yes, my lord.
This is the right position in law. A junior drawing a higher pay because of the benefit of MACP, there is no question of pay stepping up.
No, here the question is not that one, my lord.
Right? You are arguing recovery.
Yes, ma'am.
So,
Yes, ma'am.
Rafiq Masaya case, your lordship may kindly see. Yes, the bill is 3,24,000 odd rupees.
The recovery is effective, Mr. Holder.
But as per the earlier order, my lord, I have succeeded in this one. Okay, they have granted me full relief. They have said whatever the amount is paid, that will be stay with them.
We are not on merit. He is only arguing only this. Why the recovery should be effected by the tribunal in that paragraph earlier way as the tribunal should have, we find that tribunal should have decided the issue. There is no recovery. But on this observation and then leave it to you, what you have done is you have said recover.
But the pension amount is not equal. At the time of retirement, her salary was 31,100. And if he is revised, corrected, then it is 76,000.
So what you have done is the pay, the stepping up of pay, which otherwise the officer was not entitled to, which you have given, you have recovered.
Yes. And we have
Not
not
a benefit.
disturbed the pension amount.
That's right. He's only on recovery, but surprisingly, when the tribunal has said so, see, what is the use of tribunal saying so?
Page 79, my lord, there are 7.
The tribunal says so. In retired person, we make an exception that he will not be disturbed again if they have gained anything better. Tribunal should have passed an order saying that retired, no recovery. But it says both. You dispose of the representation and it says this also. What you did, you dispose of the representation, effecting the recovery.
So we have not disturbed the pension amount, but we have recovered the wrong payment earlier.
How many cases of this nature are there?
My lord, actually.
But 2 more cases filed in CH, it's pending, my lord. They are waiting for the order of this court.
There are totally 19 people have been wrongly.
And in all 19 recovery affected?
Yes, in all 19 people recovery are affected, only the petition of this authority.
So, Mr. Ola, let's give you. On recovery, possibly in law, we have seen the earlier order also where we have retired.
Yes, ma'am.
If no recovery has been effected, possibly we would be with you.
My lord, recovery has been effected when the proceedings are pending before the court. When the proceedings are pending before the court.
Effectively, complete recovery has been made.
They are retired from retirement benefits are required, my lord. Because I am entitled to the benefit of earlier order, my lord. That's all I am saying.
You were not entitled to that benefit in law.
My lord, here question, earlier order has become final, my lord, because department has not challenged this order.
Similarly placed.
No, my lord, because
There, out of these 3.
You have recovered from them also?
Yes, ma'am.
All.
Yes.
cannot be all, my lord, because 2 other persons I am handling the case now, which is pending there before CIT.
In respect of 19, this recovery has been effected.
Or maybe it have been passed, yes.
And all are retired?
All right.
All retired? No, Mr. Ola. Not in this fact, and more so this 19.
No, 19, of course, my lord, they are 90% are the parties in the original issue way. But how many of them got the amount is not known now.
It is in all 19. All 19.
So far as I know, my lord, another two,
There was one case of yours, possibly we could have exercised our discretion.
and this case, my lord, another two cases are pending in CH. That's all I'm appearing in those three cases. I'm not aware of that.
To say before the tribunal.
Only 3 or 4 have approached.
Right, but the rest have not approached.
Rest have not.
No, sir, not in this facts. It's purely a discretionary relief of.
My lord, my submission is that earlier order has become final, my lord. That's all my submission.
Tell us one thing, you're right, you be right in saying. But what made the tribunal to say dispose of the representation?
No, that is not us, my lord. Yeah, by then I was retired. Kindly read my law, but in the case of retired persons, we will make an exemption that they need not be disturbed again. If they have gained anything, let that gain stay with them.
We are saying the tribunal should have said so. No representation, I am passing an order, you will not make recovery because he has retired. What they saw, the given representation, that discretion is with me. I reject your representation.
No, representation is given, my lord, only to the extent that I have retired from the service. Then only they could have implemented the court order.
Not in this fact. We may be harsh, we know that, not in this case. The challenge in this petition is to an order given 622 passed by the Central Executive Tribunal in the fact of POAs. Thereby the tribunal has dismissed the OA filed by the petitioner being OA number 170 OA/170/00059 of 2020 by stating in paragraph 25 to 27 as under. The consequent case is that the petitioner was given the step up in pay on the ground that he being senior, on the ground that his junior was getting a higher pay than him. The case of the respondents was that the union was getting the benefit of higher pay because of grant of MACP to start. It appears that the recovery was effected at the time of the retirement of the petitioner of the benefits which have been given to the petitioner. Given to the petitioner by stepping up of her pay on the ground that such a benefit would not have been given to the petitioner. Also, when the higher pay is being drawn by the union because of the grant of MACP benefit. But in the first round of litigation initiated by the petitioner being OA number being OA number 170
545.
OB 2019 decided by the tribunal on 6th May 2020. The tribunal disposed of this right away. Along with other ways, connected ways, by stating in paragraph 6 and 7 as in the page 17. The pursuant to the directions in paragraph 6, the tribunal has granted liberty to the respondents to dispose of the representation to be filed by the petitioner. Till such time the order is part of the representation, the respondents were restrained from making any recovery. In fact, the paragraph 7 on which heavy reliance has been placed by Mr. Holla stipulates that inter alia stipulates that in the case of retired person, the benefits the benefits received by such a retired person should be allowed to stay with them. They should stay with him or with her. It is a considered position that in terms of the representation and in terms of the directions given in para 6, the respondents herein have rejected the representation of the petitioner. So it is also a conceded case. The benefits have been recovered from the retirement benefits paid to the petitioner at the time of her retirement. So the issue as urged by Mr. Holla is that in view of the conclusion drawn by the tribunal in paragraph 7, the respondents could not have recovered the benefits which has been paid to the petitioner on account of stepping up of pay. The said submission of Mr. Holla is appealing on a first blush. Is appealing, but on a deeper consideration, on a deeper consideration, more so in view of the directions given in paragraph 6 of the order of the tribunal in the earlier round of litigation, when a liberty has been granted to the respondents to consider the representation to be given by the petitioner for a decision, and pursuant thereto, the respondents have rejected their representation, with which the tribunal in the impugned order has not found fault with it. We are of the view that since that discretion has been vested with the respondents to decide the representation, and the respondents having decided the representation against the petitioner, more so the senior shall not be more so when it is a settled law that a senior is not entitled to step up of pay merely because the junior started drawing a higher salary on account of grant of MACP. The decision of the respondents cannot be faulted. And moreover, we are of the view, no doubt, no doubt the petitioner has retired from service, and in view of the law, settled law, the recovery should not be effected from a retiree, but the fact remains the recovery having been effected at the time of retirement, at the time of the retirement of the respondent, of the petitioner, and the conclusion and in view of the conclusion drawn by the tribunal in paragraph 35, we are of the view that in the facts of this case, this court and we are also of the view, and more so it is contended by the legal counsel for the respondent. There are 19 similar cases wherein the recovery has been effected. We are of the view that in the facts of this case, more so in exercise of our discretion, of our power over discretion and the Article 356. The order of the tribunal should not be interfered with. Accordingly, we dismissed with petition. With no cost, with no other expense. Thank you for.
Much obliged.
Yes.
33.
I pray for the petitions. Lords, respondent in the present OA, my lords, was seeking for a grant of financial upgradation, my lords, on par with one of the employee, my lords, with that has been granted. That is under challenge, my lords.
What was the, that's it, yeah.
He won't be the junior, my lords. I'll point out. My lords, page 8 may be seen for a moment, my lords. Lords, here, my lords, the respondent retired in the year 2014, my lords, 31/3/2014. And he made a,
What has it challenged before the tribunal?
lords, the relief is at page 85. First relief was he had challenged one of the endorsement which was issued, wherein his request was rejected.
Say, ask the junior.
No, my lords, I'll point out. Lords, page 8 may be seen for a moment, my lords. 8, my lords. Lords, here the respondent retired on 31/3/2014, my lords. Lords, on in the year 2017, he made a representation stating that he should get financial upgradation as per his junior, my lords. Lords, at page 8, the bottom there is tabular column, my lords may kindly peruse it. My lords, the first has the details. Second column is the respondent, my lords. Third column is the person to whom comparison is being made. My lord sees the details. 17/9/1976 is the LDC entry of the respondent, my lords. The other person is 14/8/1973, my lords. Next page, my lords. He joined as a sorting assistant. And my lords, the respondent cleared UDC by clearing examination on 1/3/1985. Similarly, the other person cleared on 8/4/1983, my lords. Lords, that person to whom a comparison is being made, my lords, he was under different division. He took a transfer, my lords. By virtue of that transfer, my lords, he was placed at the bottom of the transferred division. That is Rule 38. If my lord sees that Rule 38, that is not applicable to the respondent. It is applicable to the other person. My lords. He was at the bottom, my lords. My lords, later on, my lords, this LDC and UDC was merged, my lords, on 1991. As postal assistant, SPCO, my lords, on merger. 1/8/1991 is the date, my lords. My lords, at that time, my lords, the financial upgradation was in the form of TBOP and BCR, my lords. The time-bound one promotion, my lords, and bicameral centenary review, my lords.
He got first.
My lords, whom? Yeah, other person got earlier to him. Earlier to him. On 17/1/1992 is the date when he got it. This respondent got it on 17/9/1992 minutes. That is after 16 years from the service. Next column minutes, the BCR, which was given to him minutes on 1/1/2003. That is after it is issued, served also minutes, and I'm told he served minutes, and a memo is filed by him. Told. There was a in the order sheet, if my lords is 25/5/2023, my lords.
Right, so this, the respondent is represented, we notify in the interest of justice, we notify.
23-9,
Please. Much.
34, serial number 34. Street.
Are the petitioner in this matter, my lordship. Lordship, I seek 3 days accommodation. Kindly happen on Monday, my lordship. 3 days accommodation, my lord. Senior has suffered some leg injury in his leg. 3 days, my lordship. I have to prepare, my lordship. Just 3 days, my lordship. It may be personal money. Senior suffered injury in his leg, my lordship. His personal inconvenience. I'll argue, my lordship. I have to prepare, my lordship. I have some confusion in this. I'll argue on Monday, my lordship. 3 days. Please, my lordship.
Sir, 11-9.
Obliged.
We have sufficient time.
Please, my lordship. Please, my lordship.
35 adjourned, 36. Serial number 36, Sachin.
I appear to the
My lords, in this case, my lords, it may be posted on Monday, my lords, because senior is held up in quota number 8. He is ready, my lords.
Yes.
order has been seen. Take long. This shows you. The details of night one, which has been challenged. The payment of amount that they have collected from me. A clear case of arbitrariness and discrimination. Unable to be charged 159 rupees per square feet. I have been charged 1,500 rupees per square feet. Towards development charges. The brief gist is this. I purchased in 2000 itself. Is the justification? They say that the notice was issued. I received the notice, I am paid. Subsequent to which they have other petitions and one challenge it and some common orders passed the rate of 149. As I've already paid it, they say they refunded the cost financial loss. That is the reasoning given. By 2019. For the exposure, yes, for accounts. Yeah. It's the council is busy in the user code. We notify. Okay. What is the interim order? No, not one. Final orders passed. My petition is allowed.
Contempt is pending consideration, my lords, hence.
Was the prayer made by you before the trial in the verification?
I sought the refund of the exit.
Interim order may kindly be extended.
30th September.
Much.
30th September. Your name, sir.
But make any difference, they are PDA, no?
Yes, sir.
I have put the individual which means like.
So it should not take much of the time, we are giving a comfortable data here.
Not 28.
That is a better solution.
27 for 28.
27th.
26.
26th. Sir.
Don't come to our sir.
No, madam.
I started first.
No, madam.
Right, okay.
I'm ready.
Passed over matters. Team. Nineteen. Executive engineer, PBM. 19, sir. Serial number 19.
You are not parties in this. You are not party, no. Yes, how is that? But the BBA. Mr. BBA.
No, sir, notice not.
For the appearance for the of the Supreme Court. Petition is simply report and interest.
20. Srimati Renuka. Sorry, my lord, I was not present in the meeting. Lord, the respondent, my lord, was a conductor. And my lord, my lord, serial number 20, my lord, 20. My lord, the charge against the respondent, my lord, is that he was,
No, ma'am.
my lord, it's a fresh matter. My lord.
Yes.
My lord, the charge with him, with the conductor, my lord, was that he was in possession of a unaccounted cash of rupees 302, my lord. On the day in question, my lord, in the cash check form, the personal amount declared by him was nil, my lord.
For the charge,
My lord,
the issuance of ticket.
no, my lord, the possession of unaccounted cash of rupees 65, my lord, of 302, my lord. The charge sheet, my lord, I produced, my lord, at annexure, that is page 67, my lord. And there's a circular in the corporation, my lord. The circular says, my lord, on the last occasion, my lord, when this matter came up, your lordship want, my lord,
On this conclusion, merely because he has an extra.
my lord, I have a judgment of this court.
Before they start the journey.
Yes, yes.
They have to declare
Yes,
cash.
that's the, my lord, I just have a copy of the translated copy. Circular. And we have said that, my lord. My lord, the drivers and conductors, my lord, while going on duty, your duty can carry their personal amount fixed as per the schedule stated above. The said amount is required to be entered in the waybill duly signed by them. In the event of excess amount stated, is what is stated above is required to be carried by the conductors. It's required to enter the said amount in the column meant for the same in the waybill duly certified by the traffic supervisor or officer at the bus stand. And my lord, it's also said at this pass and my lord, in the event the personal amount is found with the conductor in excess of the amount in the form, the same amounts to misconduct which is punishable. And my lord, in fact, my lord, on the last occasion, I had taken time, my lord, to produce the judgment of the apex court, my lord. My lord, on non-issue of tickets, my lord, sorry, on the issue of excess cash, my lord, the judgment, my lord, the second judgment, my lord. At 8, my lord, page number 8, my lord. Divisional Controller, KSRTC versus AT Money. Well, the first judgment, my lord, is with regard to South Indian Cashews case, my lord, under section 11A. If the order of punishment, my lord, is other than that of the dismissal or removal, my lord, if the charge is proved, my lord, that cannot be interfered with, my lord. That's the first judgment. The second judgment, my lord, is on misconduct. My lord, paid for stay, my lord, the entire order is set aside, my lord. My lord? No, my lord. But denial of increment, my lord. Denial of 3 increments with cumulative effect, my lord. It's not a case of dismissal. No, no, he's not filed. My lord, if I say so, my lord, after his lordship Justice Sondi, my lord, came across this kind of cases, my lord. The same circular, I'm informed that it was introduced in the High Court also, my lord, that they have to declare the cash, my lord, their revenue. I'm informed, my lord, for some time it was there. I do not know whether it was there now, my lord. The circular, my lord, was also adopted in High Court. Yes. I think it's still there, my lord, they're confirming. Like that was before his lordship Justice only, the Chief Justice. That, I guess, N.K. Sondi.